Hear ye, hear ye, hear ye. The mock trial court of the Commonwealth of Massachusetts is now in session. Our Honorable Justice Pearson presiding, Justice Kenton Walker, and Judge Liu presiding. This court is now open. You may be seated. No talking in the courtroom, please.
Thank you. Good morning. Welcome to the mock trial, to all the parents, to all the rooters, and to the teams. Would you kindly introduce yourselves?
Good morning, Your Honor. I would like to introduce myself. My name is Mariska Pichette, and my co-counsel will also introduce themselves.
Good morning, Your Honors. My name is Alana Young.
Good morning, Your Honors. My name is Ella Lombard.
Good morning, Your Honors. My name is Sam Farnsworth.
Good morning, Your Honors. My name is Hannah McKnight.
Good morning, Your Honors. My name is Noah Loving.
Good morning. And you are representing the plaintiff, correct? And who is representing the defendant?
Good morning, Your Honor. My name is Gina Benedetto. I'm here with my team from Marshfield High School. We represent the defense today, defending Mr. Alan Sway. Again, my name is Gina Benedetto. I will be conducting the closing argument and the cross of Dr. Israel Moisen, my co-counsel.
Good morning, Your Honors. My name is Joe Proctor, and I'll be conducting the direct examination of Jody Trask.
Good morning, Your Honors. My name is Brian Bowman. I will be conducting the cross-examination of Ben Sultan and the direct examination of Dr. Jean Valdone.
Good afternoon, Your Honors. My name is Oliver Farnham. I'll be conducting the direct examination of Mr. Alan Sway and the cross-examination of Jamie Wong Nagarola.
Good morning, Your Honors. My name is Antonia Benedetto, and I'll be conducting the opening statement.
Your Honor, with your permission, we have one or two preliminary matters from the stage by way of introductory remarks.
Certainly.
Thank you, Your Honor. Thank you, everybody. Glad to see so many people here. My name is Josh McGuire, and as the chair of the MBA's Mock Trial Committee, I have the privilege of serving as the sort of master of ceremonies of today's event. Our first speaker this morning, before we get to the trial, is Robert Holloway, President-elect of the Massachusetts Bar Association. Mr. Holloway is a shareholder and president of McLean, Holloway, Doherty, Ardiff, and Morse PC in Peabody. A regular panelist for continuing legal education programs, Mr. Holloway is also an emeritus member of the Board of Editors of the Massachusetts Lawyers Weekly, having served on that board since 1981. No stranger to mock trials, Mr. Holloway is a regular volunteer as a judge for moot court arguments and serves as a trial advisor on the Harvard Trial Workshop program. He's also a long-term member of the MBA's Ethics Committee, a member and past chair of the MBA's Civil Litigation Section Council, former MBA treasurer and chair of the Budget and Finance Committee. In August 2009, Robert Holloway began a 3-year appointment to the Supreme Judicial Court's Standing Committee on Pro Bono Legal Services. It is my great pleasure to introduce the MBA President-elect, Robert Holloway.
Your Honor, Presiding Justice Pearson, if I may have permission to continue with my remarks?
Yes, you may.
Thank you very much. I always have to move the microphone down, although people tell me that I can speak loudly enough that you'll hear me without it. I have, as you can see, prepared remarks, and I've been cautioned not to depart from my prepared remarks, although I'm interested in the locales of the two finalist teams here, because I could tell you stories about the Pioneer Valley and about Marshfield, but they would probably be inappropriate in this setting, but I was tempted. It is my pleasure to welcome all of you to this 27th annual Massachusetts High School Mock Trial Finals. As they told you and as my name tag says, I am the president-elect of the Massachusetts Bar Association, and I'm frankly delighted and honored to welcome these two talented teams in this great competition, Marshfield High School and the Pioneer Valley Performing Arts Charter High School. Did I get that out right? Good, thank you. These two teams have prevailed over more than 100 other competitors to make it to today's finals. Both teams should be very proud of this hard-earned achievement. Thanks and welcome to all of you who have supported this mock trial program. Classmates, teachers, mothers and fathers, many are here, family and friends. As the father of adult children myself, I know how important your support is and how much it is appreciated by the competitors today. In this 27th championship, it is fitting that we have one team from Eastern Massachusetts and one from Western Massachusetts competing in this historic Great Hall. Faneuil Hall has been the site of important history, and each year more than or approximately 2,000 lawyers take their oath as newly admitted lawyers in this Commonwealth, in this very building. In behalf of the Mass Bar Association, and frankly, personally, I hope you have found your participation in this mock trial competition rewarding, not only for its own sake, but as a building block for success in whatever you choose to do. I want to extend special thanks to the Mock Trial Committee, chaired by Josh McGuire. There you go. And many of the committee's members are here, and also the many teachers and lawyer coaches who have guided the students through this competition. The Mass Bar Association's Director of Community and Public Services, Elizabeth O'Neill, Amy Osborne, and Joe Cacci of the MBA, I extend my thanks to you for your hard work in reference to this competition. Thanks also to the Chief Justice for Administration and Management, Robert Mulligan, and his Chief of Staff, Bob Panetton, for their assistance in providing court space and staff resources throughout the competition. And special thanks to our presiding and scoring judges, District Court Judge Barbara Savitt Pearson, who granted me permission to speak, for which I thank her, and Superior Court Judges John Liu and Janet Kenton Walker. And finally, we are greatly indebted to the law firm of Brown Rudnick, who is represented here today by Al Wallace, its executive director of public interest, its public interest center. Their generous support over many years has made this competition possible. I'd also like to thank the Massachusetts Bar Foundation, who is the philanthropic arm of the Mass Bar Association, for its support. Again, I welcome all of you, and good luck to the two teams. Thank you.
I'm going to echo a few of those remarks in introducing a representative from our sponsor firm, Brown Rudnick. Their financial support makes this entire tournament possible, something the firm has done for many years now. Al Wallace is the executive director of the Brown Rudnick Center for the Public Interest. He's an experienced attorney, as well as an executive and senior manager in both the public and private sectors. He has served under 2 Boston mayors as the city's corporation counsel, and I can tell you that none of this happens without the support that Brown Rudnick has given us over the years, and that the mock trial program has been very fortunate indeed to have Al Wallace as a vocal supporter for many of those years. I'm very pleased to bring to the podium Al Wallace.
This is great, Bob. I get to raise the microphone. It's rare for me. Good morning. I am Al Wallace. I'm with the law firm of Brown Rudnick, an international law firm which has its base in Boston, its home base. And Brown Rudnick puts all of its philanthropic and pro bono legal work under an umbrella, which we call the Brown Rudnick Center for the Public Interest, and I'm privileged to be able to lead that. It's been about, I think, about 14 years that we've been supporting the mock trials financially. The initial impetus for doing that was a partner at Brown Rudnick who happened to be Josh's father, who got us involved with mock trials. And so we've invested about maybe $350,000 thus far in this event. So on behalf of Brown Rudnick, I am really pleased and proud to be here and to be part of the mock trials. I really have only one thing to say, but I'm going to say it about 6 times. First, I want to say to the judges, it's just wonderful that the judges take the time out of their day, leave the courtroom, come out into the community, and help to spread the concept of justice and the concept of fairness beyond the norm. It's just a wonderful thing they do, and so on behalf of Brown Rudnick, I'm really pleased and proud to be here with the judges in this mock trial program. To the teachers and the coaches, what a magnificent thing that you do to teach beyond the classroom. I think the real-life experiences are probably the most powerful that one has. And we do a lot of work with after-school programs, and I think that they contribute so much to life, and particularly at this time in life, when you're in a senior year. So the coaches and the teachers that take the time to be able to focus on the individual, integrate them into the real world, really deserve our thanks. And on behalf of Brown Rudnick, I'm pleased and proud to be here with you. The parents and friends, it's got to be a struggle to see your kid, your little kid, sitting up in a place like this, probably looking a little bit different than you do around the house on the weekend in terms of the way they're dressed, being smart, articulate, involved with the world, recognized by the world. It's got to make you feel wonderful, but it's also got to be a little bit intimidating. You've got to grow with them. And so I'm really pleased and proud on behalf of Brown Rudnick to be with you who are so generous and understanding and part of the life of your children. The MBA. Mass Bar Association does a lot of wonderful things for the bar, for our community, for our state. This is one of my favorites. I think it's something that really grounds us as a legal community. And it is done so well, not just in terms of the putting it together at this moment, but the way it's organized, the way it's thought through, the value that it brings to our Commonwealth. So on behalf of Brown Rudnick, I'm pleased and proud to be here as part of the mock trial program with the MBA. And lastly, but probably most importantly, to those who are going to argue today, those who've argued throughout this whole process, gosh, guys, I think, maybe this is because I'm a lawyer, maybe it's just because I care a lot about our world and our country. I think that civil discourse, understanding other people's arguments, understanding how to articulate your thoughts, critical thinking, is the key to our future. And there is no better way to get it than through mock trial, and there are no better people at the mock trial than you here, this year at least. So on behalf of Brown Rudnick, I'm really pleased and proud to be in your presence today. Good luck in the finals.
Just a few additional preliminary matters before we get going, and I know that you are all anxious to do so, and I know that not just because I can see it in your faces, but because I have been in that chair. I have been involved with this program since 1988, when I was an 8th grader, back when they allowed 8th graders into the tournament, participating on my first state championship team. I've done this as a student, I've done it as a teacher coach, an attorney coach, a judge, been a member of this committee, and now I'm privileged to be the chair of this committee. And so I know how you're feeling. But a few other things to be said. I do want to acknowledge the other members of the committee, because while I am the chair of the committee, that is, I can assure you, as ceremonial a post as they come. It is a group effort. A number of them are here today. I'd like them to rise as I read off their names so everybody can give them a nice little thanks. Mary Bassett, Jim Barnhill, Arthur Karakatsanis, Denise Coffey, Richard Coffey, Patrick Hannon, Sharon Jones, Elliot Lowe, Deb Schreiber, and Eric Schutzbank. Those of you who are here, go ahead and stand up. I know you're out there. And our team, of course, also would not be complete without the help of the MBA staff members who are already mentioned, Elizabeth O'Neill, Amy Osborne, and Joseph Kachi. This is an effort that, as you can imagine, requires a heck of a lot of organization. And I know it's very hard to believe right now, but we even had a few snow makeups this year. So the rescheduling of trials is something that the MBA staff is responsible for, in addition to getting all the arrangements so that things like this finals work flawlessly. So we really appreciate their help as well. In selecting a topic for the case, our committee always tries to identify an issue that is both current and relevant to the students, and I don't think that we've ever done so well as we did this year on both counts. This year's case, as I'm sure you all know, deals with bullying, a topic that's been addressed frequently in the news and significantly recently by legislation as well. This being a mock trial, of course, we had to avoid a simple contest between a bully and a victim because, of course, you have to represent both sides, and defending or minimizing or mitigating that sort of behavior was not really what we were trying to do. So instead, the case addresses the question of the legal limits of responsibility for dealing with a thorny and persistent issue like bullying in the schools. How do you stop it from occurring? And the case examines whether a teacher in particular who fails to stop bullying from occurring is responsible for the harm that occurs. That question raises interesting legal issues about negligence, including legal duties and causation and other fun things like that. But it also addresses a relevant social issue, including the increasing level of responsibility that we as a society are placing on teachers and the increasing burdens they bear. And in that respect, by the way, I don't know that we've ever had a case that was as thoroughly embraced by all the teacher coaches as well as the students. It's an issue that I think speaks to everybody involved in mock trials. A few procedural reminders and the like. Of course, we are in this great hall, but we are treating it like the grandest of all courtrooms. All cell phones should be off. Think about that right now. Even if you say, yeah, I already turned it off, double check. We don't want texting, we don't want phone calls. We do have a video team that's making a video of today's event, as well as a staff photographer taking pictures that will be available on the MBA's website. If you want to supplement those things by taking pictures yourself, we really ask that you not use a flash and that you stay in your seat. We need everybody staying in their seat for the entire duration of the trial, in fact, because this is, after all, a courtroom. No hanging from the balconies, no signs, I don't see any, no air horns, and we discourage you from trying to do the wave. No food or drink in the Great Hall as well. I'm sure that everybody took care of that on their way in. And finally, please stay seated and stay with us after today's trial. We'll have an award ceremony, including, of course, the announcement of the state champion. Good luck to both teams. Show us what you got. No further ado.
Okay, you've introduced yourselves to us. We know who you are. Calling the case of Alex Salton by Bonnie Salton against Annie Sway.
Your Honor, before we proceed with opening statements, there have been a number of stipulations that were provided with these case materials. Would you like me to enter those into evidence, or would you like me to read those into the record?
If you'd like to enter them into evidence, that would be
Sure.
fine. Is there any objection?
No, Your Honor.
Also, we have a number of advisories that were posted on the MBA website as corrections to the case. Would you like me to read those into the record or enter them as evidence?
I think you can submit them. No objection to that either?
I have no objection, Your Honor.
Okay, you may approach.
Thank you.
Thank you. Thank you.
Thank you, Your Honor.
How would you like to proceed? Plaintiff.
Good morning, Your Honors. Before I proceed, I would like to reintroduce myself. My name is Mariska Pichette, and I will be giving the opening statement for the plaintiff, Ben Sultan. May I proceed?
Yes, you may.
Although Alex Sultan was a victim of bullying, this case is not about him. This case is about Mr. Alan Sway, Alex's math and homeroom teacher, who witnessed the bullying of Alex every day and did not report it. Teachers owe a duty of care to protect their students and keep them safe. Mr. Sway breached his duty. He did not protect Alex Sultan. He did not keep him safe. In September of 2009, Alex enrolled at Baird Academy as a junior. He was bullied from the moment he entered the school. This bullying escalated and resulted in an assault on October 21st, 2009. Alex was physically attacked by several bullies, one of whom was Nate Crope. To add to this assault, Alex was a victim of cyberbullying when pictures and videos of the attack were posted online. And as a result of this assault, Alex needed to be hospitalized in the psychiatric unit of the Huffington Falls Hospital. He has been there ever since. Today, we will prove by a preponderance of the evidence that Mr. Alan Sway, Alex's math and homeroom teacher at Baird Academy, breached his duty to Alex as his teacher, and that his negligence was the proximate cause of the harm Alex suffered. Mr. Sway was an experienced educator, and he was trained to recognize and report bullying. Yet, he did not report the bullying incidents he witnessed prior to October 21st. This assault and the harm caused by it could have been avoided had the defendant, Mr. Sway, reported any of the bullying incidents he witnessed before the assault on October 21st. In August of 2009, Alex and his brother Ben Sultan moved to Huffington Falls. Alex then enrolled in the reputable private school, Baird Academy. Before school began, Alex met Mr. Sway. The evidence will show that Mr. Sway knew of Alex's parents' death and the extraordinary circumstances which brought him to Baird Academy. Mr. Sway was not only a veteran teacher at Baird Academy, but also a significant member of the committee that wrote the Baird School anti-bullying policy. Your Honors, the bullying began on Alex's very first day of school and continued on a daily basis. When Mr. Sway heard bullying comments about Alex in his classroom, he did nothing. You will hear from one of Alex's classmates, Jamie Wang Nogarola, that Alex was significantly affected by the bullying and that he visibly changed as a result. Ms. Nogarola will testify that Mr. Sway was often present when Alex was being bullied, including when the primary bully, Nate Crope, and his friends cornered Alex and played keep-away with his backpack. Mr. Sway himself observed that Alex became noticeably more quiet and isolated every day, and still, he did nothing. The evidence will show that Mr. Sway also knew that Alex had been subjected to cyberbullying. Ms. Nogarola will testify that on September 15th, photoshopped and sexually suggestive pictures of Alex were posted online. This cyberbullying was reported directly to Mr. Sway, and he chose not to make an immediate report as required under the Massachusetts bullying law. On the night of October 20th, when Mr. Sway met with Alex's legal guardian, Mr. Sultan, Mr. Sway still said nothing. Even after Mr. Sultan asked Mr. Sway directly if anything might be bothering Alex, Mr. Sway insisted that Alex just needed to work harder, choosing to deliberately withhold the information about the bullying acts that he had witnessed. Today, Dr. Israel Moisen, an expert in both psychiatry and bullying prevention, will testify that she personally conducted the anti-bullying trainings at Baird. Mr. Sway was trained to recognize and report bullying, as well as what signs to look for in bullying victims. Dr. Moisen will testify that Mr. Sway's failure to report and stem the tide of bullying before the final assault was the cause of Alex Sultan's breakdown. Your Honor, Mr. Sway did not keep Alex safe. He did not carry out his duty as a teacher. He chose not to report the bullying of Alex. What happened to Alex Sultan was avoidable, and had Mr. Sway fulfilled his duty, it would not have occurred. We are confident that upon reviewing all the evidence presented here today, you will find that the defendant, Mr. Alan Sway was negligent, and that his negligence was the proximate cause of the tragic injury of Alex Sultan. Thank you.
Thank you. And the opening for the defense.
May I proceed, Your Honors?
Yes, you may.
Today, you'll hear the case of Mr. Alan Sway, a dedicated and experienced teacher at Baird Academy for over 12 years. During the 12 years that Mr. Sway was a teacher at Baird Academy, he was forced to work with an administration that was more concerned with the reputation of the school than it was with the actual well-being of the students in it. He was forced to work in a culture at Baird that was reluctant to confront bullying in any of its forms. In other words, Mr. Sway was adrift in a sea of administrative indifference towards bullying at Baird Academy. Being a math and homeroom teacher, Mr. Sway would see over 100 students per day, and he was constantly called upon to differentiate between playful teasing, typical adolescent behavior, and conduct that actually constituted bullying. This was a difficult task for Mr. Sway because of the simple fact that he is not a headmaster. Mr. Sway is not a guidance counselor, he is not a police officer, and Mr. Sway is not a school psychiatrist. His primary responsibility is to educate his students, and he is merely a conscientious teacher doing his very best to do just that. Being a teacher at Baird Academy, Mr. Sway had the responsibility of following the Baird anti-bullying and harassment policy, which lays out exactly what a teacher should do when and if they become aware that bullying has occurred. Once becoming certain that bullying has occurred, the teacher is directed towards the disciplinary committee, and from there, all bullying reports would head to the subcommittee, which merely consisted of one sole member, Headmaster Hurtwich. The plaintiff has alleged that my client, Mr. Alan Sway, was negligent. Negligence, as the court is aware, is defined as the failure of a responsible person, either by omission or by action, to exercise a degree of care which a person of ordinary caution and prudence ought to exercise under the particular circumstances. The plaintiff has the burden of proof in this case with respect to all four elements of negligence, including duty, breach of duty, resulting damages or injury, and proximate cause. To prove all four elements of negligence to you today, the plaintiff will attempt to bring to your attention several instances of student interactions, and they will contend that these interactions consisted of bullying. However, my client was not present for all these interactions, and it will be undisputed that Alex was actively trying to conceal what was going on at Baird Academy, and in doing this, he deprived Mr. Sway of the chance to act. Mr. Sway was not Alex's only teacher. In fact, Ben Sultan had 2 other parent-teacher conferences with other of Alex's teachers, and at neither of these conferences did any teacher ever mention the word bullying. However, when Mr. Sway reached the same conclusion that Alex was not being bullied, the plaintiff decided to single him out and accuse him of negligence. The defense will call 3 witnesses to the stand today. The first will be Mr. Jody Trask, a former student and now graduate of Baird Academy. Having been a former student and a member of the disciplinary committee, Mr. Trask is extremely familiar with the Baird anti-bullying and harassment policy, and he will testify and demonstrate to the court the obvious flaws that this policy contains, including the obvious inefficiency of having one person be the sole member of the subcommittee, and this person be Headmaster Hurtwich. He will prove to the court how Headmaster Hurtwich, ignoring bullying instances such as the ones occurring to Alex Sultan, was not unusual at Baird Academy. The second witness the defense will call is Mr. Alan Sway himself. Mr. Sway's primary responsibility is to educate his students, and he was not even aware what was taking place at Baird Academy until the night of October 20th, when Jamie Wong Nagarola brought to his attention for the very first time that Alex was being subject to cyberbullying on a website known as the Friend Connector. Jamie brought with him a screenshot of this website to show that Alex was being subject to cyberbullying. However, this screenshot indicated in no way that Alex was in imminent danger of physical harm the next day. The following day, October 21st, Alex was subject to physical abuse on the football field by Nate Crope. Mr. Sway immediately reported this instance of bullying, and Nate Crope has since been expelled and is now facing criminal charges, all as a direct result of the defendant's responsible conduct. The third and final witness the defense will call to the stand is Dr. Jean Veldon, a clinical psychologist who received his degree in psychology from Yale University and his degree in counseling and guidance from Boston University. Dr. Veldon will add to Mr. Trask's testimony about the obvious flaws of the Baird anti-bullying and harassment policy, and he will also testify to his analysis of Alex's state of mind before even attending Baird, proving that Alex was already suffering from subclinical depression before even meeting the defendant, which means that the defendant's actions or inactions had no bearing on Alex's present state of mind. Your Honor, today you'll hear the case not only of Mr. Alan Sway, but you'll hear the story of Alex Sultan. Although no one will argue that Alex's story is tragic, I ask you to keep in mind that hindsight is always 20/20.
It is easy to point fingers, blame, and speculate 3 years later, once the outcome of a situation is known, just as the plaintiff is doing here today. But to accuse my client, a teacher, of negligence, simply because he's easiest to blame, would only further add to the tragedy of Alex Sultan's story. Through evidence and through testimony, the defense will prove to you today that Mr. Sway's actions or inactions had no bearing on Alex's present state of mind. And for these reasons, we ask you to find the defendant not negligent and that his actions were not the proximate cause of Alex's present condition. Thank you.
Thank you. Ready? Okay. Plaintiff would like to call your first witness.
Yes, Your Honor. The plaintiff calls Mr. Ben Sultan to the stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter? Yes. You may be seated. You may proceed.
Thank you. Please state your name for the record of the court.
My name is Ben Sultan.
What is your current address?
I currently live at 823 Chestnut Street in Huffington Falls, Massachusetts.
How long have you lived in Huffington Falls?
I have lived in Huffington Falls since mid-2009.
What brought you to Huffington Falls?
When our parents died in mid-2009 in a car accident, my brother Alex and I had to start a new chapter of our lives together.
How did your parents' accident affect your family?
It affected our family hugely, but being younger than I was, it hit Alex harder than it did me. He'd attended grief counseling ever since their deaths, though, and over the summer he'd gotten a lot stronger.
Why did you decide to send Alex to Baird Academy?
Objection, Your Honor. This assumes facts, not an evidence. There's no foundation for this question.
Sustain, you may lay a foundation.
Did you send Alex to Baird Academy?
Yes, I did.
Objection, Your Honor. That is a leading question, and we'd asked for the answer to be stricken from the record.
Overruled.
Thank you. I will repeat my question. Did you send Alex to Baird Academy?
Yes, I did.
Did you have reasons to send Alex to Baird Academy?
Yes, Bayard was an incredibly reputable school, and I thought that it would be a great place for a smart kid like Alex.
What was your first official encounter with the school?
My first official encounter was a compulsory orientation session which parents were made to attend.
What happened at that orientation?
There, speakers
Objection,
talked for
Your
you.
Honor. The scope of that question is too broad. It calls for narration.
Overruled.
I will repeat my question. What happened at that orientation session?
There, speakers talked for nearly 2 hours about Bayard Academy.
Did they mention bullying at all?
Yes, near the end, I believe they briefly mentioned the Bayard Academy anti-bullying policy.
Permission to approach the bench to have this document marked as Exhibit A for identification purposes only.
Show it to your...
I've already shown it to opposing counsel.
You may approach. Thank you. Mark that Exhibit A. Would like it back?
Your Honor, may I approach the witness?
Yes, you may.
Could you please identify that document?
Yes, this is the Bayard Academy harassment and bullying policy.
Did you obtain a copy of that bullying policy?
Yes, I did.
Where did you obtain a copy of the policy?
All parents were given a copy at the end of the compulsory orientation session.
Is this a fair and accurate copy?
Yes, it is.
Your Honor, may I retrieve the document?
Yes, you may.
Your Honor, at this time, I ask that this document be moved into evidence as Exhibit 1.
Any objection?
No objections, Your Honor.
Yes, you may. Thank you.
Turning your attention to the summer of 2009, when did Alex first visit Baird Academy?
Alex toured the school campus a few weeks before the first semester started.
Who did Alex meet at this tour?
At that tour,
Objection, Your Honor. I would like to respectfully ask my opposing counsel to move out of the way of my line of vision to the witness. I cannot see.
Fair enough.
Thank you.
I will repeat the question. Who did Alex meet at this tour?
At this tour, Alex met Jamie Winogrola and Mr. Sway, who turned out to be his math and homeroom teacher.
Once the school year began, did you witness any interactions between Alex and other students?
Objection, Your Honor. Under Rule 201, that is a leading question.
Yes, Sustained. And if you just step back, maybe 3 more steps, then they can see. Sustained.
Did you drive Alex to school at any point at the beginning of the school year?
Yes, I picked him up from school in the first week for a doctor's appointment.
Did you witness any interactions between Alex and other students?
Yes, there were a couple kids that appeared to be making fun of my little brother.
Did you see Alex often at home?
Yes, we had dinner together almost every night.
How did you think Alex was doing academically at Baird?
I thought that Alex was doing fine till I received his midterm warnings in early October.
Relevancy?
Had you received any contact from the school before you received the warnings?
No, no one had told me anything.
What did the warnings say?
The warning said that Alex was practically failing 3 of his classes, one of which was even his favorite class, math.
Was this typical of Alex's prior academic performance?
No, not at all. Alex had always been an excellent student.
What did you do?
I immediately made an appointment to meet with all of his teachers.
How did you meet Mr. Sway?
I met Mr. Sway at the parent-teacher conference I had about Alex.
How long was it before this conference occurred?
It was 2 weeks before they had a free appointment for me.
What did you discuss with Mr. Sway?
We discussed Alex's grades, and I tried to say that Alex is a very smart student and that there must be some other reason for his poor grades.
What was Mr. Sway's response?
Mr. Sway told me that Alex obviously needed to work harder to prove that he belonged at a place like Baird.
Did Mr. Sway say anything else?
Yes, he did. He personally assured me that he would keep a close eye on Alex for me.
What, if anything, happened when you got home from that meeting?
When I got home from that meeting, I saw that Alex's eyes were red as if he'd been crying, but he kept turning away from me and saying that he didn't want to talk to me about it.
How did you interpret this behavior?
I thought that maybe he was just worried about what his teachers had said about him.
Did you do anything in response to Alex's state?
Yes, I did. I told him that his teachers had said some very nice things about him, which appeared to make him feel better. However, I was still very worried, so I emailed Mr. Sway to ask if there was anything else that could be bothering Alex.
Did you ever get a reply to that email?
No, I never got a reply.
What did you do?
Well, the next morning, even though I hadn't heard back from Mr. Sway, I trusted him when he said that he was looking out for Alex for me, so I thought that it would be okay to send Alex to school.
What happened the next time you saw Alex?
That night when I saw Alex, he was crying hysterically, and I didn't know why. I was so terrified by this that I immediately called an ambulance to take him to the hospital.
Had you ever seen Alex like this before?
No, not even since our parents' death.
30 seconds counts.
Thank you. Where is Alex now?
2 years later, he's still in the psychiatric ward.
No further questions, Your Honor.
Thank you. You may cross-examine him. Is everyone, just a minute, is everyone ready? Everyone ready for him? Okay, you may cross-examine.
Mr. Sultan, your brother was obviously devastated by the death of your parents, wasn't he?
Yes, who wouldn't be? Half our family was gone.
In fact, he even had to seek grief counseling, correct?
Yes, I thought that it would help with the loss.
So naturally, he was in a fragile state, correct?
He was at the beginning of the summer, yes.
Yet he was still able to complete his sophomore year at Semaphore Heights, wasn't he?
Yes, being an excellent student like he was.
In fact, he even excelled there.
Yes, definitely.
He had a stellar academic record, didn't he?
Absolutely.
And at Semaphore Heights, your brother had a very close inner circle of friends, correct?
Yes, he did.
Yet despite all of this, you still decided to move your brother away from Semaphore Heights, didn't you?
We decided
Excuse me,
that...
Mr. Sultan, yes or no?
We decided,
Excuse me,
yes.
yes or no?
Objection, Your Honor. I would ask the opposing counsel allow my witness to answer the question.
You may answer the question.
We both decided that Bayard Academy would be a good place for him, yes.
Mr. Sultan, you were aware that Baird Academy was a very prestigious school, weren't you?
Oh, yes, it had an amazing reputation.
It had a rigorous curriculum, too, correct?
Yes, it was known for that.
And you called their orientation pretentious, didn't you?
It did make a lot of note of their stellar record.
Yet you still decided to enroll your brother Alex at a place like Baird, even though he was in a fragile state.
By the end
Choose
of
me, Mr. Sultan, yes or no?
He wasn't in as fragile a state then.
Mr. Sultan, just 1 week into your brother's enrollment, while picking him up from school, you witnessed an incident involving him and some of the other kids at Baird Academy, correct?
Yes, I did.
These kids were making fun of Alex, saying, "How could a kid from Semaphore Heights afford a car like yours?"
Objection, Your Honor. This statement is hearsay.
Your Honor, it's not being offered for the truth of the matter asserted.
Yes, I did hear someone say that to him.
But you weren't very concerned about these kids making fun of your brother, were you?
I was a bit...
Excuse me, Mr. Sultan, yes or no?
I wasn't that concerned.
In fact, you even thought it was funny, didn't you?
I thought it was somewhat humorous.
But Alex didn't, did he?
It was clear that Alex was not amused by the
He
statement.
got really quiet, correct?
Yes,
And his lips started to quiver.
it did appear
And
to.
you could tell that your brother was upset.
Yes, I didn't know why, though.
Did you ever ask him why this made him upset?
Knowing Alex like I do, I figured it was better not to pry.
Mr. Sultan, did you ever ask him?
Objection, Your Honor. Again, I ask the opposing counsel allow my witness to finish answering the question.
Your Honor, if I may be heard, this is cross-examination, and it's a simple yes or no.
He has a right to answer the question. Sustained.
Did you ever ask your brother how these kids at Baird were treating him?
Knowing him like I do, it was better not to pry.
And seeing these kids making fun of your brother, did you ever intervene?
It didn't seem like they were making fun of him at the time.
Mr. Sultan, did you ever report this?
I had no duty to.
Did you do anything at all?
I just tried to carry on.
Mr. Sultan, when you received Alex's midterm warnings, you scheduled a meeting with Mr. Sway, correct?
Immediately.
But you didn't just meet with Mr. Sway, did you?
No, I met
You met with
all the
each of
teachers.
Alex's teachers, correct?
Objection, Your Honor. Whether Mr. Sultan met with each of Alex's teachers is not relevant to whether Mr. Sway reported the bullying of Alex that was occurring at Baird Academy.
Sustained.
Mr. Sultan, did any of these other teachers ever inform you of any incidents of bullying whatsoever regarding your brother?
No, they didn't know him that well.
But they would have seen your brother just like Mr. Sway on an everyday occasion, correct?
Not as much as Mr. Sway did, no.
But they were still his teachers, and they still could have observed him in the classroom, correct?
In their classrooms, yes.
Yes. Now, Mr. Sultan, you had a copy of the Baird Academy anti-bullying policy, didn't you?
Yes, I was given a copy.
You had read it.
Sorry, I didn't hear
You
that
had read
question.
the document, didn't you?
Yes, I had.
And you were familiar with it.
Yes, mostly.
And you saw your brother every single day.
Yes, we always had dinner
You
together.
ate dinner with him every night.
Exactly.
Time, counsel, you're getting close. You're at it now.
And you had access to your brother's friend connector page, didn't you?
No, I didn't.
Well, you were friends with him on the friend connector, weren't you?
I had an account that I tried to make a couple years ago, but I never used it.
One more question.
But you were still listed. One more question? But despite all of this, you still never suspected that your brother was being bullied until after the events of October 21st. Isn't that a fact?
I had received
Excuse
nothing
me,
to
Mr.
suggest
Sultan.
that.
Yes or no?
Your Honor, I ask that opposing counsel allow my witness to finish his answer.
Okay, but that calls for a yes or no answer.
Would you like me to repeat the question?
Yes, please, Brother Counsel.
Even though, despite all of your prior testimony, you never suspected that your brother was being bullied until after the events of October 21st, did you?
No.
I have no further questions, Your Honor.
Anything on redirect?
Yes, Your Honor. To your knowledge, did you observe any acts of bullying on Alex Sultan?
No. Never.
Did you receive any contact from the school or Mr. Sway about Alex being bullied?
Objection, Your Honor. That is outside the scope of my cross-examination.
I'll repeat the question. Did you receive any contact from the school or Mr. Sway about Alex being bullied?
No, nobody told me anything about my brother.
No further questions, Your Honor.
Yes, Your Honor. Mr. Sultan, you just testified that, to the best of your knowledge, you never witnessed your brother being bullied, correct?
Yes.
Yet you still saw kids making fun of your brother, saying, "How could a kid from Semaphore Heights afford a car like yours?" Didn't you?
They were making fun of him.
Excuse me, Mr.
Yes.
Sultan, yes or no?
Yes, I did see that.
Nothing further.
Okay. All set? Thank you. Ready? Your next witness?
The plaintiff calls Jamie Wang Nogarola to the stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter? Thank you. You may be seated.
And good afternoon, Your Honors. My name is Alana Young, and I will be conducting this examination.
Thank you. You may begin.
Please state your name for the record.
My name is Jamie Wang Nogarola.
Where did you attend school?
I graduated from Baird Academy last year.
Did you know Alex Sultan?
Yes, I do. I know him well.
How did you meet Alex?
I was working in the admissions office in the summer of 2009, and I gave Alex and his brother Ben a tour of the school.
Did you keep in touch with Alex after the tour?
Yes, I did.
How did you keep in touch with him?
After the tour, we exchanged cell phone numbers and we texted over the summer.
Did you see Alex before school started?
Yes, I did.
When did you see him?
I invited him to a party at the home of one of my friends from the debate team.
Did Alex meet anyone in particular at this party?
That was
Objection,
where he
Your
met
Honor.
Nate Crope.
Under Rule 201, that is a leading question.
Your Honor, my witness is free to answer however they choose.
I didn't hear you?
My witness is free to answer however they choose.
Yes, no, overruled.
Would you like me to repeat the question?
Yes,
Did Alex meet anyone in particular at this party?
that was where he met Nate Crope.
How long have you known Nate Crope?
I've known Nate since I was a freshman.
And in this time, have you noticed anything in particular about Nate Crope?
Nate is the ultimate Baird student. He's a really popular jock, and I've seen him harass a lot of people.
So how did you react when Nate met Alex?
I was worried because I knew right away that Alex wasn't the kind of person
Objection,
who would
Your
fit in
Honor.
with Nate and his friends.
This is irrelevant testimony.
Your Honor, may I be heard? Your Honor, this is relevant to show that when Miss Nogarola saw Nate meeting Alex, she was able to tell immediately that Alex would not be the kind of person who would fit in with Nate Crope. This goes to show that as a reasonable person, she could tell this, whereas Miss Sway could not.
Sustained.
Once the school year began, did you notice anything in particular about Alex?
Alex was laughed at and made fun of from the very first day of school.
Who made fun of Alex?
It was usually Nate Crope and his friends.
When Nate Crope and his friends made fun of Alex at school, what did you see them doing to him?
They would make fun of his clothes and his old phone. He was laughed at and bullied every day.
When Nate Crope and his friends bullied Alex, where did it take place?
Objection, Your Honor. The defense objects to the use of the word bullying as has not been established.
Sustained.
May I rephrase my question?
Yes, you may.
When Nate and his friends made fun of Alex at school, what did you see them doing to him?
They would make fun of his clothes and his old phone. He was laughed at and made fun of every day.
And when they made fun of him every day, where did this occur?
Most of it happened in classrooms and hallways with students and teachers in them.
And were any teachers present for these incidents?
Mr. Sway was often present.
And when Mr. Sway saw this happening, what did he do?
He didn't do anything. Sometimes he would ask what was going on as if he didn't know, and still do nothing.
Did anything else in particular happen between Nate and Alex?
Nate and his friends would play keep away with Alex's backpack.
And was Mr. Sway present when this happened?
Yes, he was.
And what did Mr. Sway do then?
Well, one time he intervened and told everyone, including Alex, to stop horsing around and get to class.
Did you ever talk to Alex about the bullying?
I offered to speak to a teacher about it.
And
Your Honor, the defense again objects to the use of the word bullying.
may I be heard, Your Honor? The witness has established that Alex was made fun of on a daily basis, and the court is aware of the definition of bullying, so the witness has established enough to call what this was bullying.
May I be heard, Your Honor? This witness is not testifying as an expert witness. She has no basis to opine on whether or not this is bullying or not.
Well, she can have an opinion. The witness can give an opinion. I'm asked that you not use the word in your questioning, but I'm going to overrule you with regard to the witness.
Would you like me to rephrase the question? Restate the question?
Yes.
Did you become aware of any other bullying by Nate?
Nate posted some really disgusting pictures.
Objection, Your Honor. I would renew my objection.
I've asked that you not use the word bullying. The witness
yes.
can use it in her
I'm sorry.
observations, not as an expert, but as her observations. But I ask that you not use the word. Thank you.
Did you become aware of any other interactions between Alex and Nate?
Nate posted some really disgusting pictures of Alex on the friend connector. They were clearly photoshopped, and Alex was mortified.
When were these photos posted on the friend connector?
They were posted on September 15th.
Did you do anything about this?
Despite my promise to Alex, I
Objection,
reported
Your Honor. The plaintiff is referring to a document, not in evidence.
You want to be heard on that?
Your Honor, the witness has testified that there was something posted on the friend connector, and she's just providing further explanation as to what happened to that.
What was the question?
The question was, did you do anything about this?
She can answer what you did overruled.
Did you do anything about this?
Despite my promise to Alex, I reported the bullying to Mr. Sway.
And when did you report this to Mr. Sway?
I reported it twice in the same day in early October.
And the first time you approached Mr. Sway, what did you tell him?
I told him that I was concerned for Alex and what was happening to him.
And how did Mr. Sway respond?
He didn't respond. He didn't seem to be listening to me.
Did you try to approach Mr. Sway again?
Yes, I did.
What did you do?
I went back to my room and got the pictures from the friend connector. Then I went back later that evening and showed them to him.
And how did he react this time?
He didn't ask me any questions about what I had just told him. He said that he was aware of Alex and had the situation under control.
And after this, did Nate stop making fun of Alex?
No, the bullying got worse until it ended with the final incident.
And what was the final incident?
On October 21st, Nate and his friends surrounded Alex on the football field.
And what did they do to Alex?
They had taken his underwear and pulled it over his head and left a footprint on his face. A lot of kids were laughing and taking pictures.
Did Mr. Sway do anything about this?
He showed up as it was happening.
And after this incident, how was Alex?
After this incident, Alex ran away from Baird, and we never saw him there again.
Less than 15 seconds.
Thank you, Your Honor. No further questions.
Thank you. You may cross-examine.
May I proceed, Your Honor?
Yes, you may.
Ms. Nogarola, you met Alex Sultan at the beginning of the 2009-2010 school year, isn't that correct?
I gave him a tour in the summer.
In fact, this was his first introduction to Baird Academy, isn't that correct?
I don't know if it was his first introduction.
And on this tour, you noted that Alex seemed shy and nervous, didn't you?
He seemed a little shy, yes.
You also met Ben Sultan on this tour?
Yes, I did.
And you were made aware of the circumstances regarding Alex's parents' death and Ben's legal guardian. He was a legal guardian of Alex, isn't that correct?
Yes, Ben told me.
Before you went on this tour, you also knew Nate Crope, didn't you?
I've known Nate since I was a freshman.
And you knew that Nate was a bully, didn't you?
He is.
In fact, in your affidavit, you described him as a real terror.
He is.
Self-important and conceited.
He's very conceited, yes.
And a typical dumb jock, isn't that correct?
He is.
And in your affidavit, you said you didn't think that Alex would fit in with these type of people, isn't that true?
I didn't think that, no. I mean, I didn't think he would fit in with them.
You thought that he wouldn't fit in with Nate Crope and his gang, isn't that correct?
Yes.
Yes. And in your affidavit, you also state that Crope and his gang often messed with the less popular students at Baird Academy, isn't that correct?
Yes, they were bullies.
And being a new kid at Baird might make you less popular than someone like Nate Crope, isn't that correct?
Yes, Nate was a really popular jock.
Over the summer, you invited Alex to a party, is that right?
Yes, at the home of one of my friends from the debate team.
And at this party, Alex met Nate Crope for the first time.
Yes, he did.
And Nate asked him to join him on the Friend Connector, a popular social networking site at Baird Academy, isn't that correct?
Yes.
And you had some reservations about letting Alex join this site, isn't that correct?
I told him that a lot of kids at Baird could be pretty mean.
You thought Alex might get bullied on this website, isn't that correct?
Yes, I did.
But you didn't stop Alex from friending Nate.
Objection, Your Honor. Relevance.
Overruled.
Would you like me to ask the question again?
Yes.
You didn't intervene and stop Alex from friending Nate, did you?
Well, I told him my concerns.
Once they got started at the school year at Baird Academy, the 2009-2010 school year, Alex was picked on by Nate and his gang, wasn't he?
Yes, every day.
They called him a sympathy case, and they told him he didn't belong at Baird, isn't that correct?
Yes, unfortunately, they were very cruel.
And Alex was devastated by this, wasn't he?
Yes, he was.
Now, you had Ben Sultan's contact information, isn't that correct?
I believe so, yes.
In your affidavit, you stated that you called Ben Sultan later on.
Yes,
Isn't
I
that
did.
right? But you didn't call Ben Sultan at this point.
Objection, Your Honor. Relevance.
Overruled.
Would you like me to repeat the question?
Yes.
You didn't call Ben Sultan at this point when Alex was devastated by this picking on.
Not at this point, no.
No. Now, there was also a very sexually explicit photograph posted on the Friend Connector. Isn't that correct?
Yes, it was disgusting.
On September 15th?
I believe that's the date, yes.
And this photograph was up all the way until October 21st. Isn't that correct?
I believe so.
A full month.
Yes.
And you knew that this photograph was posted. Isn't that correct?
I found out about it later, yes.
Yes. But you didn't do anything about it, did you? You waited until the 21st.
Objection, Your Honor. Relevance. My witness owes no duty of care to report any bullying of Alex Sultan, and therefore this is irrelevant.
No, I think it has to do with notice. Overruled.
Would you like me to ask the question again?
Yes, please.
You didn't bring this information to anyone, did you?
Yes, I did. I brought it
not
to
until the
Mr. Slay.
21st. I'm sorry, I misspoke.
No.
Not until the 21st did you bring this information to anyone.
No, I reported it in early October.
Yes. You had enough time to have a conversation with Alex before you brought this information to Mr. Sway. Isn't that correct?
No, I had a
Please
conversation
answer my question,
with
yes
Alex
or no.
before.
You had enough time to have a conversation with Alex Sultan.
No, I had the conversation before I found out about the pictures.
After the photographs were posted, before you brought them to Mr. Sway, you had time to have a conversation with Alex Sultan. Isn't that correct?
After they were posted, but before I found out about them, yes.
Yes. And in this conversation, Alex begged you not to tell anyone about these photographs. Isn't that correct?
He begged me not to tell anyone about the other bullying. I didn't know about the photographs yet.
He also begged you not to tell anyone about the photographs.
I didn't know about them yet, so no.
He made you promise that you wouldn't tell anyone about the other incidents.
Yes, he did.
Ms. Nagarola, Alex was actively trying to conceal the bullying that was occurring at Baird Academy, wasn't he?
Yes, he was worried
further
that
questions,
he'd
Your
never
Honor.
be
Your
accepted.
Honor. This calls for beyond the scope of the witness's knowledge.
May I be heard, Your Honor? Ms. Nagarola just testified that Alex begged her not to tell anyone and made her promise not to tell anyone. I feel that this is adequate basis to assume that he was trying to conceal the bullying.
May I be heard, Your Honor?
No, sustained.
No further questions.
Anything on redirect?
No redirect, Your Honor.
Okay. Very well. Thank you. Your third witness.
The plaintiff calls Dr. Israel Moyson to the stand.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter? Yes. Thank you. You may sit down.
May I proceed, Your Honor?
Yes, you may.
Please state your name for the record of the court.
My name is Dr. Israel Moyson.
And what is your educational background?
I received my bachelor's degree from the University of North Carolina's Chapel Hill School, and I received my medical degree from the University of North Carolina's School of Medicine in 1998.
Dr. Morrison, what is your current occupation?
I currently hold 3 positions at the UMass Medical Center and School in Worcester. I am the Assistant Director of the Division of Child Psychiatry. I am the Director of the Child Psychiatry's Consultation and Liaison Service, and I also teach psychiatry and pediatrics.
Dr. Morrison, have you testified as an expert before?
Yes, I have testified as an expert witness on bullying issues multiple times in both state and federal trials.
And what, if any, experience do you have in the field of bullying prevention?
In 2006, the Department of Elementary and Secondary Education Services hired me as a consultant to design and distribute a model bullying prevention and intervention plan for the state of Massachusetts, an assignment which I completed in 2007.
Your Honor, may I approach the bench to have this document marked as Exhibit B, I believe, for identification?
Yes, it may. Thank you. We'll mark it as B. You may have it back.
May I approach the witness?
Yes, you may.
Dr. Morrison, could you please identify this document?
This is my curriculum vitae, which I have prepared.
And is everything contained in this document true and accurate?
Yes, it is.
Your Honor, may I retrieve the document?
Yes.
Your Honor, at this time, I would request this document be moved into evidence as Plaintiff Exhibit 1.
No objection?
I have an objection, Your Honor. I believe that this document contains cumulative evidence, as we have already heard that about Dr. Moisen's educational background, her occupational history, the fact that she's testified in other trials, so I don't believe it is necessary for this document to be entered.
Overruled. I'll allow you to.
I do have another objection, Your Honor. Under Rule 502, the procedure for entering this evidence requires that counsel lay foundation for this document to be entered. We have not heard what specific information is contained in this document and who prepared this document.
Your Honor, may I be heard? Dr. Morrison has already testified that she prepared this document. This is a standard curriculum vitae containing her work experience, education, and other stuff.
Overruled. Thank you.
Your Honor, at this time I would request that Dr. Morrison be qualified as an expert in the fields of pediatric and adolescent psychiatry, bullying prevention, and the creation and implementation of bullying prevention plans.
Any objection?
No objection, Your Honor.
Fine. So done.
Dr. Morrison, how did you become involved in this case?
Alex Sultan's attorneys hired me as an expert to review his counseling and medical records and to render my opinion as to his condition and the circumstances that led to it.
And have you had any direct interaction with Baird Academy in regards to their bullying policy?
Yes, I conducted the anti-bullying training for Baird Academy in 2008 and all subsequent trainings.
And what did you cover in these trainings?
I covered a variety of bullying precursors, as well as a typical and well-known response by the victim of bullying, which is to deny that any bullying is happening. I also distributed my model bullying prevention and intervention plan and instructed the staff about the reporting requirements under Massachusetts state law.
Dr. Morrison, what, if any, observations did you make about the culture at Baird Academy?
The culture at Baird Academy is tolerant of bullying, and everyone at Baird Academy is a participant in this culture.
Now, Dr. Morrison, what was the extent of the bullying that Alex Sultan suffered at Baird Academy?
The bullying included insults, social isolation by a large number of his classmates, as well as severe physical abuse. Alex was also the victim of cyberbullying via the Friend Connector and via text message, as well as a devastating and violent physical assault.
And Dr. Morrison, what was the effect of the cyberbullying that Alex Sultan suffered?
The cyberbullying devastated Alex. He was already socially awkward and withdrawn. The fact that a large number of his classmates participated in the online harassment hurt him severely. Additionally, the fact that the Friend Connector photos were allowed to sit unreported for weeks after staff became aware of them allowed their effects to continue long into October.
Dr. Morrison, have you reached an expert opinion as to Alex Sultan's current psychological state and its cause?
Yes, I have.
And on what do you base this opinion?
I base my opinion upon my interview with Alex, my review of his counseling and medical records, my review of the affidavits in connection with this case, as well as my extensive training and experience in the fields of adolescent psychiatry and bullying prevention.
And Dr. Morrison, what is Alex Sultan's current psychological state?
The subclinical depression that Alex suffered from prior to his enrollment at Baird Academy was worsened and amplified. Alex Sultan currently suffers from acute and chronic depression, as well as several related conditions.
And what is the cause of this depression?
Alex Sultan was on the path to recovery and would have recovered from his subclinical depression in time. However, Alex was the victim of vicious bullying at Baird Academy, and it was this horrendous final assault that pushed him over the edge and caused his hospitalization, which continues to this day.
Now, Dr. Moisen, in your expert opinion, did the actions of Ms. Sway have any effect on Alex Sultan's current psychological state?
Objection, Your Honor. This question calls for the witness to give an opinion on the ultimate issue, and under Rule 704, that is not allowed, even for an expert witness, as she is testifying to approximate cause, which is one of the 4 pillars of negligence.
Your Honor, may I respond? Under Rule 704B, it specifically states that expert witnesses may not testify to the ultimate issue in a criminal proceeding. This is a civil proceeding.
Your Honor, if I may be heard. 704 subsection B does deal with criminal cases, but 704 subsection A is silent on the issue of witnesses giving opinions on the ultimate issue of this case. Dr. Moisen is an expert and may testify to the actions or inactions of Mr. Sway, but she may not opine on whether or not those actions were the proximate cause of Alex's current condition, as that is an ultimate issue and must be decided by the judges in this case.
Your Honor, may I respond? Under 704A, it specifically states that evidence otherwise admissible is not objectionable because it embraces the issue to be decided by the trier of fact.
Well, I think that the trier of fact would give the appropriate weight to her opinion, and she can give her opinion. It's a matter of weight, not admissibility. I'll overrule the objection.
Do you need me to repeat the question?
Yes, please.
What, if any, effect did the actions of Ms. Sway have on Alex Sultan's current psychological state?
It was the gross negligence of Ms. Sway and her failure to responsibly and appropriately deal with the bullying of Alex Sultan that had the biggest effect on Alex Sultan's current psychological state.
And why is this your opinion?
Mr. Sway's actions were completely inappropriate for a teacher and did not abide by Baird Academy's anti-bullying policy or the Massachusetts state law. Mr. Sway had been trained on how to prevent, recognize, and report bullying, and in spite of this, when presented with the horrendous bullying of Alex Sultan, he failed to do so. Had Mr. Sway acknowledged the bullying of Alex Sultan and reported it in a timely and appropriate manner, the final assault on the football field, which caused Alex's suicidal thoughts and hospitalization, could have been prevented.
You're over time.
Thank you, Your Honor. No further questions at this time.
You may cross-examine.
May I proceed, Your Honors?
Yes, you may.
Dr. Moisen, you are not a high school teacher, are you?
Objection, Your Honor. Relevance.
Your Honor.
Overruled.
Thank you. Would you like me to repeat the question?
No, thank you. I am not a high school teacher.
And Dr. Moisen, you are not a guidance counselor, are you?
I am a psychiatrist and a licensed psychologist.
Please answer my question, yes or no, Dr. Moisen. Are you or are you not a guidance counselor?
I do not currently hold that position, however, I am qualified to do so.
Dr. Moisen, you have never worked in a guidance office, have you?
No, I have not.
And you have never worked as an administrator at Baird Academy or any other high school, have you, Dr. Moisen?
No, I have not.
And you were hired as a professional consultant in 2006 and 2007 to the Massachusetts Department of Elementary and Secondary Schools, isn't that correct?
Yes, that is correct.
And this was during 2006 and 2007, isn't that correct?
Yes, it is correct.
But they did not hire you again in 2008, did they, Dr. Moisen?
I had already completed...
Please answer my question, yes or no, Dr. Moisen. They did not hire you again in 2008, did they?
Objection, Your Honor. I would request that counsel allow my witness to finish her answer before cutting her off.
It calls for a yes or no answer. Did you answer the question?
They did not hire me again in 2008. I had completed what I had been hired to do.
And they did not hire you again in 2009 and 2010, did they, Dr. Moisen?
They hired me for a specific assignment.
Please answer my question, yes or no, Dr. Moisen.
I completed my job, so no, I was not rehired.
Your Honor, I would like to strike the portion of that answer other than the word no as non-responsive.
Sustained. Please answer just the question. Thank you.
Dr. Moisen, you were retained by the plaintiff in this case, were you not?
Yes.
And this is when you first met the younger brother of the plaintiff, Alex Sultan, isn't this correct?
Yes, it is.
And when at this first meeting, you conducted an interview of Alex Sultan?
Yes, I did.
And you met with Alex Sultan for 1 hour, isn't that true?
Yes.
And during this meeting, you recall that he was shy?
Yes.
And you recall that Alex Sultan was passive?
Yes, he was.
And you recall that he was introverted at this interview, isn't that true?
Yes, he was.
But doctor, you did not conduct another interview of Alex Sultan, did you?
No, I did not. It was not necessary.
You conducted only one meeting with Alex Sultan, isn't that correct?
Yes, that was all I needed.
And if you had conducted another meeting of Alex Sultan, you would have learned more about him, isn't that true, Dr. Moisen?
Objection, Your Honor. This is irrelevant as it calls for speculation that the witness would have no way to know.
Calls for speculation. Sustained.
Dr. Moisen, at Baird Academy, Alex Sultan was concealing his emotions from Mr. Sway, isn't that true?
I'm not entirely certain of every time, but he did deny that he was being bullied.
So he did deny that he was being bullied to Mr. Sway, isn't that correct?
That is a typical and well-known response, and he displayed it,
Please
yes.
answer my question, yes or no.
Yes, he denied that he was being bullied.
And Mr. Sway reached out to Alex, didn't he?
I believe so, yes.
Mr. Sway asked Alex if everything was okay at Baird Academy?
Yes, he did.
And Alex Sultan responded that everything was cool, isn't that correct, Dr. Moisen?
It is a typical and well-known response.
Please answer my question, yes or no, Dr. Moisen. This is how he responded?
He responded typically as a victim of bullying would, yes.
I would like to strike everything but the word yes from that witness's answer as unresponsive. And Mr. Sway gave Alex Sultan his phone number, isn't that correct?
I believe so, yes.
And Mr. Sway told Alex Sultan to call him whenever he needed to, isn't that correct?
I'm not sure exactly what he said, but I believe so, yes.
And Alex Sultan never called Mr. Sway, did he?
Not that I'm aware of, no.
And Alex Sultan never told Mr. Sway that he was being bullied, isn't that correct?
No, he did not.
Thank you, Dr. Moisen. So it is fair to say that Alex Sultan was concealing his emotions from Mr. Sway.
This is a typical and well-known response by victims of bullying.
Please
Mr. Sway had been trained on how to recognize this.
Dr. Moisen, I did not ask you if this is a typical response. I merely asked you if Alex did conceal his emotions.
Yes, he concealed the bullying.
And on October 20th, Ben Sultan met with Mr. Sway for a parent-teacher conference. Isn't this correct?
Yes, that is correct.
But Mr. Sway is not the only teacher that Ben Sultan met with. Isn't this a fact?
I believe so, yes.
And none of the other teachers at these meetings told Ben Sultan that Alex was being bullied. Isn't that true?
I am not aware of that.
And so Ben Sultan, you were here for Ben Sultan's testimony, weren't you, Dr. Moisen?
Yes, I was.
And Ben Sultan told this court today that he was not aware of the bullying incidents at Baird Academy. Isn't that true?
That is what he said, yes.
So it is fair to say, Dr. Moisen, that no teachers told Ben Sultan that that Alex was being bullied. Isn't this correct?
I suppose so, yes.
Thank you. You testified today that Alex was bullied at Baird Academy?
Horrendously so, yes.
And you testified that Alex was experiencing depression from the death of his parents before he entered Baird. Isn't that correct?
Yes, he had subclinical depression.
You're over time, counsel.
If I may have just a few more questions.
2 more questions.
Okay. If I may draw your attention to your affidavit. Permission to approach the bench?
Yes.
I would like this document marked for identification purposes as Exhibit C.
Okay. No
May I
objection.
approach the witness?
No objection.
No objection, Your Honor.
Fine. Yes, you may.
Just a few questions, Dr. Moisen. If I may draw your attention to paragraph 12 of your affidavit.
2 questions.
Dr. Moisen, I'm sorry, if I could draw your attention to paragraph number 9. And please read along silently as I read aloud. You say that the bullying exacerbated Alex's depression. Isn't this correct, Dr. Moisen?
Yes, that is what I said.
Dr. Moisen, did Mr. Sway bully
Objection,
Alex?
Your Honor. Your Honor has given opposing counsel 2 questions, and she has exceeded this.
This is my final question, Your Honor.
Final question.
Did Mr. Sway bully Alex, Dr. Moisen?
Not that I'm aware of, no.
Thank you, Your Honors. No further questions.
Redirect?
No redirect, Your Honor.
Okay. Thank you. You're all set. You can we keep going? Let them keep it. Okay. Okay. Anything else for the plaintiff?
The plaintiff rests, Your Honor.
Thank you. Defense counsel want to call its first witness, please?
At this time, the defense calls Jody Trask to the stand.
Want to stand and be sworn in, please? Do you swear or solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth in this matter? Thank you.
May I proceed, Your Honors?
Please.
Please introduce yourself for the court.
My name is Jody Trask.
Did you attend high school?
Yes, I graduated from Baird Academy in 2011, cum laude.
Now that you've graduated from high school, what are you currently doing?
I'm currently enrolled in a national outdoor leadership school.
During your time at Baird Academy, what, if any, activities did you participate in?
At Baird Academy, I was the captain of the Ultimate Frisbee team, and I was also a member of the disciplinary committee.
How did you become a member of the disciplinary committee?
At the end of my sophomore year, I was nominated by my peers to serve.
What, if any, training did you receive for the committee?
In order to serve on the committee, all prospective members were required to attend a 3-hour seminar that was led by Ms. Moisen.
Who else attended this seminar?
Mr. Sway was also at this seminar.
What did you learn from attending this seminar?
I wasn't able to really learn a whole lot of anything at this seminar.
And why is that?
Well, the seminar was only 3 hours long, and bullying is a very broad topic, and I didn't feel that enough was covered at the seminar to really explain bullying.
Objection, Your Honor. This testimony is speculation.
Overruled.
Did you receive any materials at the seminar?
Yes, among other things, we received a checklist with some very vague indicators that bullying could be occurring.
May I approach the bench?
Yes, you may.
At this time, I'd like to have this document marked for identification.
Any objection?
No objection.
Fine, thank you.
May I approach the witness?
Yes, you may.
Do you recognize this document?
Yes, I do. This is the checklist we received at the seminar.
What information is contained in this document?
Again, this document contains some extremely vague indicators that bullying could be occurring.
Who developed this document?
Dr. Moisen developed this document.
Your Honors, at this time, I'd like to have this document entered into evidence.
Any objection?
No objection, Your Honor.
Fine.
As a member of the disciplinary committee, did you use this document in completing your required duties?
Well, I wish I could have, but this document wasn't useful to me at all.
And why wasn't it useful to you?
As I previously stated, all the indicators...
Objection, Your Honor. This witness's opinions on this checklist is irrelevant.
This is, you want to be heard?
Yes. Yes, please. Under Rule 701, subsection A lay witness may give opinion testimony if it is rationally based on the perception of the witness, and as the witness has been extensively trained in matters of bullying and has more knowledge than the average witness, this opinion is rationally based on his perception.
Overruled. We'll apply weight to it as opposed to admissibility. You may continue.
Would you like me to repeat the question?
Yes, please.
As a member of the disciplinary committee, did you use this document in completing your required duties?
No, I did not.
And why not?
As I previously stated, all these indicators are much too vague and really could be used to describe teenage interaction that occurs on a day-to-day
Your Honor,
basis.
this is an opinion this witness is not qualified to make. Jody Trask does not have any sort of qualifications to talk about how the checklist works or how effective it is.
Your Honor, if I may be heard.
Yes.
This is the same objection that she previously stated and you overruled.
But the answer, you have to have a foundation to put that answer in. He can give an opinion, but he's gone beyond the opinion that you initially asked him to give.
Okay. Does Baird Academy have a bullying policy?
Yes, it does.
Please describe the Baird bullying policy.
Although the Baird bullying policy does address the issue of the definition of bullying and a few other key points, it doesn't actually require a teacher to report bullying when they see it. It doesn't address the issue of reformation of a bully when they are caught and disciplined, and it doesn't address at all the issue of counseling for victims of bullying. It simply relies on draconian punishments to deal with bullies when they are caught.
What observations do you have of the Baird bullying policy?
The Baird bullying policy is a complete joke. It doesn't have any teeth, and it simply exists so that
Objection, Your Honor. This is an opinion this witness is not qualified to make.
Your Honor.
Overruled.
Can you repeat the question?
What observations do you have of the Baird bullying policy?
The Baird bullying policy is a complete joke. It's simply window dressing, and it has no teeth, and it exists so that Headmaster Hurtwich can show it off to donors.
Objection, Your Honor. This is speculation. This witness would have no knowledge as to what Headmaster Hurtwich.
You can cross-examine him on it. Overruled. Continue.
What is a teacher required to do in the event of a bullying incident?
When a teacher suspects or even actually sees bullying, nowhere in the Baird policy does it actually require a teacher to report it. It states that a teacher should report bullying when they see it, but it never actually states that a teacher must report bullying when they see it.
And what is done when a bullying report is filed?
When a bullying report is filed, it goes to the disciplinary committee, but before any action can be taken, it is referred to a subcommittee of the disciplinary committee.
What is the subcommittee?
Well, when a report is filed, it goes through the disciplinary committee to the subcommittee, and the subcommittee then decides to either act informally based upon the report, or then take action based upon the report and call a full-fledged disciplinary committee meeting.
Who are the members of the subcommittee?
To the best of my knowledge, the only person who has ever been a member of the subcommittee was Headmaster Hurtwich.
And what are the powers of the subcommittee?
The subcommittee has complete control over all disciplinary issues at Baird. Upon receipt of a report, the subcommittee can decide to act informally, it can decide to do nothing at all, or it can decide to call a disciplinary committee meeting and take action.
How many disciplinary committee meetings did you have during the 2009-2010 school year?
We only had one meeting, and that was the meeting to expel Nate Crope.
And why did you have this meeting?
We had this meeting because of Mr. Sway's immediate report after the physical assault on the football field.
Do you know Alex Sultan?
Yes, I do.
When did you first meet Alex Sultan?
I met Alex at the beginning of our junior year at Baird in our Spanish
I'll
class.
set your time, counsel. Close.
Please describe what Alex was like when you first met him.
When I first met Alex, he seemed to be kind of shy and withdrawn, but he seemed to be an overall good person.
What other friends did you know of him having?
I knew Alex was friends with Nate Crope, which was very strange to me.
Why'd you find this to be strange?
I found this to be strange because Nate Crope was an all-star athlete. He was an amazing student, and Alex didn't seem to have very good grades, and he didn't participate in any extracurricular activities. And it was just strange that such polar opposites would hit it off so well.
One more question.
Was Alex Sultan's case the only report filed to the disciplinary committee during the 2009-2010 school year?
No, it was not. I filed numerous reports directly to Headmaster Hurtwich about issues such as sexual misconduct and hazing, and they were completely swept under the rug.
No more questions.
You may cross-examine.
Yes, Your Honor. Good morning, Your Honor. Once again, my name is Hannah McKnight. May I proceed?
Yes, you may.
You were a member of the disciplinary committee at Baird, weren't you?
When I attended, yes.
And you had to attend a training in order to join this
Objection.
committee?
I would respectfully ask that the opposing counsel please take a few steps to the side so that I may see my witness.
Yes, if you'd step back. Thank you.
Could you repeat the question?
Yes. You had to attend a training in order to join this committee?
Yes, all prospective members did.
And Mr. Sway was also at this training?
Yes, he was.
This training was on identifying and reporting bullying behavior?
Yes.
Now, you testified that you filed numerous reports of bullying, didn't you?
I filed numerous reports of sexual misconduct and hazing.
And you say that nothing was done about these reports?
That's correct. Nothing was done.
Now, you are familiar with Baird's bullying policy, are you not, Mr. Trask?
Yes.
And it was a subcommittee of the disciplinary committee that initially handled all reports of bullying.
They chose whether or not to take action on it, yes.
And that's a yes, Mr. Trask?
Yes.
And the headmaster was the only member of this subcommittee?
To the best of my knowledge, no one else had ever served on the subcommittee, so yes.
And according to the Baird bullying policy, isn't this subcommittee required to initially deal with reports in a confidential manner?
Yes.
So you would have no idea how bullies were punished?
Yes, I would.
But this was confidential information, wasn't it?
No, I would have known how the bullies were punished.
But Mr. Trask, didn't you just testify that this information was confidential to the subcommittee?
What the headmaster did was confidential, but the disciplinary committee found out about the punishments he gave.
But this is not stated in the bullying policy, is it, Mr. Trask?
I don't remember off the top of my head. I
And this
haven't
is
seen the
also-
policy for years.
And this is also not stated in your affidavit, is it, Mr. Trask?
Hold on, let him finish the answer. Is that your objection? Yeah, let him finish the answer.
I haven't seen the bullying policy for quite some time. I graduated Baird in 2011.
Mr. Trask, this information is not stated in your affidavit either, is it?
Not that I know of, no.
Now, you say that Baird has a culture with serious disciplinary problems, don't you?
Yes, it does.
And athletes are the worst offenders?
Most of the time.
Nate Crope is an athlete, isn't he?
And a very good one at that.
And they were responsible for these serious disciplinary problems, weren't they?
Who's they? The athletes?
Nate Crope and his group of friends.
The athletes in general were responsible.
You called Nate and his group of friends a group of thugs in your affidavit?
Nate didn't hang around with the best crew.
And so that's a yes, Mr. Trask?
Yes, it is.
Now, Alex told you that he was friends with Nate Crope, didn't he?
They were practically best friends.
And they harassed Alex too, didn't they?
No.
But in your affidavit, you stated that Alex was having problems with Nate and his gang?
Yes.
They would play keep away with Alex's hat, wouldn't they?
Yes, they played around all the time.
And this seemed to happen a lot to Alex?
It seemed to happen a lot in general.
But in your affidavit, you pointed out that this seemed to happen a lot to Alex?
Well, yeah, they were playing around.
And you noticed that Miss Sway would be present during some of these episodes, wasn't she? Wasn't he?
Mr. Sway was often present, yes.
And Alex would act as if it didn't bother him?
No, it seemed to me that it didn't bother Alex.
You stated in your affidavit that when Mr. Sway was present, he would act as if it didn't bother him?
Not in the sense that it actually did.
Mr. Trask, that was not my question. I asked if you wrote in your affidavit that he would act as if it didn't bother him.
It didn't seem to bother him, so
So that's a yes, Mr. Trask?
yes.
Now, you were also aware that they would shove Alex around physically, weren't you?
They would horse around, yes.
And this was occurring routinely?
It happened from time to time.
But you wrote in your affidavit that this was occurring routinely?
Yes.
And you talked to Alex about this, didn't you?
We had a brief conversation.
You didn't think it was appropriate for them to do this to Alex?
Well, I don't think shoving around in the hallway is exactly the most appropriate thing. Someone else could get bumped into.
So that's a yes, Mr. Trask?
Yeah, it's not entirely appropriate, no.
So you thought this was bullying, didn't you, Mr. Trask?
No, it was horseplay.
So these group of thugs, as you call them, would routinely shove Alex around, and you didn't think that this could be bullying?
Alex's friends would horse around, and that was not bullying, no.
So that's a no, Mr. Trask? These thugs would shove him around, and you didn't think this was bullying?
Your Honor. The question has been asked and answered.
Your Honor, I'm clarifying the witness's answer as he did.
Overruled. You're over your time, counsel, by 10 seconds.
Okay, so that's a no, Mr. Trask?
2 more questions.
What's a no?
That you did not think that these thugs shoving around Alex could be bullying?
Alex horsing around with his friends in the hallway is not bullying, no.
That's a no, Mr. Trask?
No.
Thank you, Your Honor. No further questions.
Anything on redirect?
Yes, Your Honor.
You may.
Why is it that you did not make any reports concerning the horseplay in the halls with Alex and Nate?
Well, there was no reason to. There was no bullying going on. No one seemed to be extremely humiliated, physically abused,
Objection,
ostracized.
Your Honor. This document is not in evidence, and therefore the witness cannot read from it.
Don't refer to anything, but you can answer the question.
He was not extremely humiliated, ostracized, or physically abused. It seemed to be just perfectly normal horseplay that occurs between teenage boys.
Thank you. No further questions.
Any
No recross, Your Honor.
Thank you. Thank you. Your next witness?
The defense calls Mr. Alan Sway to the stand.
Swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you.
May I proceed, Your Honor?
Yes, you may.
Please introduce yourself to the court.
My name is Alan Sway, and I live at 53 Peter Street, Martins Landing, Massachusetts.
What is your current occupation, Mr. Sway?
I'm currently a mathematics instructor at Baird Academy, and I have been for the past 12 years.
Could you please summarize your educational background for the court?
Certainly. In 1992, I received my degree in education from the University of South Florida. In 1995, I received my master's in mathematics from Brandeis University.
Are you a psychiatrist, Mr. Sway?
No.
Are you a psychologist?
Absolutely not.
Are you a guidance counselor?
No.
Do you have any type of law enforcement background?
None at all.
Objection, Your Honor. Relevance?
Overruled.
Mr. Sway, as an educator at Baird Academy, what are your priorities in regard to students?
Well, I have 5 classes, which meet 4 times a week, which is approximately 100 students. Now, my job as an educator is to instruct and ensure the successful future of each and every one of these students.
With over 100 students per week in the fall of 2009, how much time could you realistically spend with each individual student?
Objection, Your Honor. This is a leading question.
Overruled.
Would you like me to repeat the question?
No, I'm fine, thank you. Realistically, it's practically impossible to sit down with each and every individual student and talk about their personal grade. I have to correct homework, quizzes, papers, and tests and maintain their grades as it is.
Do you know Alex Sultan, Mr. Sway?
Yes, I do. Alex was one of my students in the 2009-2010 school year, and I met him a few days before that school year started.
Before you met Alex Sultan, did you receive any information on his background?
Yes, I was provided with his file and made aware of his delicate situation coming into Baird.
During his first few weeks at Baird Academy, what were your observations of his academic success?
Academically, unfortunately, Alex was struggling. He was practically failing 3 of his classes, including my own.
How is Alex doing socially, from your perspective?
Socially, I thought he was doing just fine. He was nervous, yes, but he told me that he had met a bunch of kids, including Nate Crope.
Who's Nate Crope?
Nate Crope is a very publicized student at Baird. He's an academic all-star and 3-sport athlete.
What did you observe about the friendship that developed between Nate and Alex?
It seemed like a totally normal high school friendship. They'd play around the halls, push each other around, completely normal.
Do you know?
Objection, Your Honor. This is speculation.
Overruled.
Do you know Ben Sultan, Mr. Sway?
Yes, I do. Ben is Alex's older brother and legal guardian, and I met him on October 20th at around 8 p.m. after I sent out some midterm warnings regarding Alex's grades.
What occurred at this meeting?
Well, we were there on the topic of Alex's failing grades, so I gave Ben some study habits that could be implemented to help improve.
Before this meeting with Ben, did you observe any incidents in the hallway with Alex and Nate?
Yes. After they'd been playing around, I noticed that Alex was accidentally tripped.
What, if any, action did you take in regard to this incident?
I told Headmaster Hurwitz about it in passing.
To your knowledge, did Headmaster Hurwitz do anything with this report?
No, he did not.
To your knowledge, did Headmaster Hurwitz ask Alex about this report?
I was never made aware of this, no.
Did you tell Ben Sultan about this incident?
Absolutely not. I respect this sort of teacher-student confidentiality. Now, if it was regarding Alex's safety, of course I would have brought it to Ben's attention, but it was a playful gesture amongst friends.
Are you involved with anything else at Baird Academy?
Yes, I'm a member of the disciplinary committee at Baird.
What is this committee responsible for?
We drafted the anti-bullying harassment policy.
What does this policy cover?
It covers the definitions of bullying, harassment, cyberbullying, what a teacher or student should do in the situation of bullying, and safe places for a student to go if they feel they're being attacked.
In 2008, did you receive a document regarding this policy?
Yes, Headmaster Hurwitz sent out an email to all faculty, including myself.
May I approach opposing counsel?
Yes, you may.
May I approach the bench?
Yes, you may.
I'd like to have this document marked for identification.
Any objection?
Not at this time, Your Honor.
May I approach the witness, Your Honor?
Yes, you may.
Thank you.
Do you recognize this document, Mr. Sway?
Yes, I do. This is the email that Headmaster Hurwitz sent out to myself and the rest of the faculty.
What is contained within this document?
It summarizes Headmaster Hurwitz's views on the policy, what he thought.
At this time, I'd like to enter this document into evidence as the defense's next exhibit.
Objection, Your Honor. This document is hearsay.
May I be heard, Your Honor? This document goes to prove the state of mind of Headmaster Hurwitz at the time of the email, and it also is a regularly conducted course of business, which is a hearsay exception. The institution of Baird Academy uses these documents to communicate with teachers. It's regular, it's a faculty email list.
Your Honor, may I be heard? Your Honor, this email is not a regularly conducted business activity. It is an isolated email regarding an isolated event and therefore does not qualify under this hearsay exception. In addition, an email from a headmaster to the faculty at his school cannot accurately reflect his inner state of mind.
This is not being introduced for anyone's state of mind.
No, it is not.
I'm going to allow it into evidence. Overruled.
Mr. Sway, could you please read for me the first sentence of the second paragraph of this document?
Certainly. I want to stress the importance of attending Dr. Morrison's presentation. Bullying has been a hot topic in the press recently, and I've started getting questions about it on recruiting visits and at fundraisers.
Could you also please read for me the very last sentence of this document, beginning with the words, I want to?
Yes. I want to make sure that we are above reproach on this one.
After reading this document, Mr. Sway, what do you feel it reveals about the attitude of the administration toward bullying?
Clearly, Headmaster Hurwitz views the policy as window dressing.
Objection, Your Honor. This is speculation.
May I be heard, Your Honor?
I would sustain the objection to the question, and you can ask another question.
Mr. Sway, do you know Jamie Wong Nagarola?
Yes, I do. Jamie was one of my students in 2009, and in regards to this case, he brought to my attention some very disturbing photos of Alex.
What do these photographs show?
The photographs showed Alex had been in a very compromising situation for farm animals, very explicit. It was very embarrassing as well.
When were these photographs brought to your attention?
On October 20th, around 10 p.m., late at night.
Have you ever seen these photographs before?
No. Apparently they'd been up for over a month, and this was the first time I ever heard of them.
Why hadn't you seen them before?
They were posted on the front connector.
Objection, Your Honor. The question calls for speculation.
Sustained. 30 seconds.
Mr. Sway, during the time that Alex Sultan spent at Baird Academy, did you ever reach out to him in any way?
Yes, as much as I could. Before the school year even started, I gave him my personal phone number so he can contact me whenever he felt necessary, even after hours. During the times in school when I saw any incidents regarding him and the other kids, I approached him and said, "Are you okay?" And he assured me he was. Around mid-October, when I saw he was struggling, I sent out some warnings to Mr. Sultan to inform him of what was going on. And after the incident on the football field, I called the family but never received a response.
Why did you reach out to him in such a way?
It wasn't just Alex. I would do this for any student. If any student is being bullied or is having a hard time at school, they can't learn and they can't have a successful future, which is my job to ensure.
You're over your time.
Your Honor, there have been several objections. May I ask for 3 more questions?
You may ask 3 more quick questions.
Mr. Sway, did you have the authority to suspend or expel Nate Crope?
No, I did not.
Did you have the authority to move a disciplinary report past the subcommittee of the disciplinary committee?
No.
Who did have this power?
All these powers rested on Headmaster Hurwitz, him only.
No further questions, Your Honor.
Cross-examine.
Yes, Your Honor. May I proceed?
Yes, you may.
Now, you believe that Headmaster Hurwitz's email shows that he cares about bullying only as a public relations issue, correct?
For fundraisers and recruiting visits, I believe he was more interested in the money than anything else, yes.
But this is just your opinion, isn't it?
But judging on the email, it's a rational opinion, yes.
So that's a yes?
Yes.
Now, you've been a teacher at Baird Academy for 12 years, is that correct?
Yes, I have.
And you've been trained to recognize bullying, correct?
Somewhat. The orientations given were not the best that they could be.
But you have officially been trained, is that right?
Attempted to be trained, yes.
Now, in a typical day, you observe multiple disciplinary concerns, correct?
Somewhat, yes.
In fact, one day you heard Alex Sultan referred to as the new dumb kid, is that correct?
Yes, I did.
Now, Alex told you that he was friends with Nate Crope and his gang, correct?
Yes.
But you observed that these students largely ignored Alex, is that right?
Not just these students. He was a new kid in school. It's typical for a new student not to be going out of the way to be acknowledged or to be talked to.
Mr. Sway, that was not my question. Alex was largely ignored by the students, is that right?
When he passed in the hall, yes.
And when he wasn't being ignored, he was cornered and they were cornering him and playing keep away with his possessions. Is that right?
This was a singular incident. It was not every time he was not being ignored, no.
But Mr. Sway, don't you state in your affidavit that the exceptions to him being ignored were when Nate Crope and his friends would corner him in the hallway and play keep away with his hat?
Yes, this is only one.
So that's a yes?
Yes.
This happened repeatedly, didn't it?
I observed one incident.
You stated in your affidavit the exceptions to this pattern, correct?
Yes, but the incident I talked about is a singular one.
So that's a yes?
No, the incident I am talking about
Excuse
in my
me,
affidavit.
Mr. Sway, that was not my question. You stated exceptions in your
Objection, Your
affidavit.
Honor. I would ask my opposing counsel to allow my witness to finish his answer.
Well, I think the answer needs to be responsive. You can ask the question again.
Thank you. So you did use the word exceptions in your affidavit, is that
I
correct?
do, but these were only some. When he was at home, he wasn't being cornered or attacked.
Now, you talked to Alex after one of these incidents, didn't you?
Yes, I did.
And Alex denied being bullied, didn't he?
I don't think he was bullied at all. He said he was okay.
And he told you that everything was cool?
Yes, he did.
But you know that students often deny they're being bullied, don't you?
No, I do not. I don't think he was being bullied at all.
But this was covered in the bullying training that you attended, was it not?
Briefly, and it wasn't covered very well, so I couldn't recognize the situation.
Excuse me, Mr. Sway. So that's a yes, it
Your
was
Honor.
covered in the training?
Your Honor.
You can allow him. Overall, you can allow him to answer.
Barely, yes.
And he asked you not to tell anyone what you had seen?
Yes, he did.
Now, soon after this, you met with Alex's guardian, Ben Sultan, didn't you?
October 20th at around 8 p.m., I did.
And wasn't he concerned that something at school might be bothering Alex?
Yeah, obviously the grades were, yes.
But you didn't tell him any of the incidents that you'd observed with Alex Sultan, correct?
Absolutely not.
And so you deliberately withheld information from Alex's guardian?
I didn't think there was any information to withheld. Alex lives with his older brother. I assumed he would know if anything was happening at school that he would tell him about. He asked him how he was every night.
But Mr. Sway, you didn't tell him any of this, correct?
No.
Now, soon after your meeting with Mr. Sultan, Jamie Noguerola approached you, correct?
At around 10 p.m. She did.
And she confirmed that Alex was being bullied, didn't she?
She gave me her theory that he was.
And she showed you evidence of cyberbullying?
Yes, she provided me with a photograph that was very embarrassing to Alex.
Now, you're required to report any bullying immediately, aren't you?
If there's a endangerment to his safety, yes.
So that's a yes, you're required to report it immediately?
Yes.
But you didn't report this example of cyberbullying until more than 14 hours later. Is that correct, Mr. Sway?
First of all, I had to sleep, so there's no possible way I could have done that. But yes, it was far too late at night at the moment, and I wouldn't receive a response if I tried to report it.
Your Honor, motion to strike everything but yes is unresponsive to my question. Thank you, Your Honor. No further questions.
Read it.
May I have a very brief moment to consult with my co-counsel?
Yes, you may.
May I proceed, Your Honor?
Yes.
Mr. Sway, did any of the events occurring before the date of October 20th, 2009, constitute bullying?
Absolutely not. There was no imminent threat that Alex was going to be hurt or harmed or emotionally impaired. Absolutely not.
What must happen at Baird Academy before a formal bullying report is filed?
There must be substantial evidence that bullying is occurring. I cannot base a bullying report off speculation or off a theory that a student has provided me.
Did you have enough information to file a bullying report before the date of October 21st?
Absolutely not. There is no instance of bullying to report.
No further questions, Your Honor.
Recross?
No recross, Your Honor.
Thank you.
Thank you.
And your next witness.
The defense calls Dr. Jean Veldone to the stand.
Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in this matter, so help you God? I do. You may be seated.
May I proceed, Your Honor?
You may.
Please introduce yourself to the court.
I'm Dr. Jean Veldone. I live at 30 Arden Ave, Boxborough, Massachusetts, where I've resided for the past 15 years with my wife and 3 children.
What is your current occupation, Dr. Veldone?
Currently, I am a clinical psychologist specializing in the development of affirmative programs to prevent and deal with bullying in the middle and secondary schools. My proudest moment of work in this specialty is that when I invented RIPE, and this is an acronym that stands for Respect Your Peers and Yourself. This program has been implemented in over 30 schools, each and every one of these.
Objection, Your Honor. The witness is narrating.
Your Honor, if I may be heard, although the witness's answer may be long, it is not narration as it is all responsive to the question that was asked.
May I be heard briefly? The question called for what his current employment is. The creation of the RIPE program is not his current employment.
Your Honor, if I may be heard, that is part of his current employment.
Okay. Overruled, and keep your answer a little more brief and to the point of the question.
So RIPE is the program in which I invented, and it has been in place in over 30 schools, and I've trained each and every single one of these schools, and I currently am still training them when they choose to place my program. And each and every single school I've trained has reported positive feedback. Currently, I'm a professor at the University of Massachusetts Lowell, where I train students as well as run their clinical services division on caring for adolescents and their school-related problems.
Please summarize your educational background.
Certainly. In 1980, I received my bachelor's in the arts of psychology from Yale University, and then after that, I enrolled myself in a clinical psychology program at Boston University, where in 1982, I received my MED in counseling and guidance, and then finally in 1987, I received my doctorate from the same Boston University.
May I approach opposing counsel, Your Honor?
Yes, you may.
May I approach the bench?
Yes, you may. Thank you.
At this time, Your Honor, I would like for this document to be marked for identification.
No objection.
No objection.
May I approach the witness?
Yes.
Do you recognize this document, Dr. Veldone?
I do. This is my curriculum vitae.
What information is contained on your curriculum vitae?
This document contains an accurate summary of my professional experience, educational background, certifications I've received, publications I've authored, as well as conferences I've attended and organizations I've partaken in.
What publications have you authored?
Well, I've authored many publications. Most recently, I've authored 2 books, and the first of which is Why School Anti-Bullying Policies Don't Work, and the second has to be my favorite piece of work, and that would be The Bully, the Bullied, and the Bystander.
What certifications have you received in your field?
I've been certified by the National Board of Professional Counselors.
What, if any, professional conferences have you served on?
Well, most recently in this past March, I served on the White House Conference for Anti-Bullying, where I was not only a presenter, but I was a panel monitor.
Is your curriculum vitae complete and accurate to the best of your knowledge?
Yes, it is.
At this time, Your Honor, I would motion to enter this document into evidence as the defense's next exhibit.
No objection, Your Honor.
Fine, thank you.
At this time, Your Honor, I would also tender Dr. Veldone as an expert in the field of clinical psychology with a subspecialization in bullying prevention and the development of anti-bullying programs.
No objection to that either, Your Honor.
Fine, thank you.
Have you been retained in this case by the defense?
Yes, I have.
Have you been compensated for the time you have devoted to this case?
I received my normal compensated rate that I would for my work given or time served for this case.
What professional tasks were you asked to perform?
I was asked to do 4 things, the first of which was to review the anti-bullying policy in effect at Baird Academy during the fall semester of 2009. The second was to review Alan Sway's compliance with that policy. Third, I was asked to review Alex Sultan's time at Baird Academy through his enrollment. And finally, I was asked to review Alex Sultan's present mental condition.
May I approach opposing counsel, Your Honor? May I approach the bench?
Yes, sir.
This time, I would like for this document to be marked for identification purposes.
For identification? No objection?
No objection.
May I approach the witness? Do you recognize this document, Dr. Veldon?
I do. This is Massachusetts anti-bullying law.
Are you familiar with this statute?
I reviewed in my preparatory work, yes.
Are you familiar with the requirements contained in the statute concerning the development of anti-bullying programs throughout the Commonwealth?
Yes, I am. This statute requires that all Massachusetts schools have an anti-bullying policy in place that must make all students and staff aware of what bullying is as well as the consequences for bullying. It must teach how to protect oneself from bullying as well as teach how to report bullying. It must show how parents and police will be involved in all scenarios of bullying as well as show how the scenarios of bullying will be resolved for both the victim and aggressor.
Dr. Veldon, are you familiar with the Baird Academy anti-bullying policy that was in effect during Alex Sultan's enrollment there?
Yes, I am.
Have you reached an expert opinion as to whether or not this bullying policy met the requirements contained in Massachusetts general law?
Yes, I have. In my expert opinion, certain portions of the policy address the bare minimum of the statute, but unfortunately other portions don't address it at all.
In your expert opinion, which portions do not satisfy the requirements?
The Baird anti-bullying policy does not properly integrate an idea of anti-bullying through education into the students, which the statute requires, nor does it properly deal with the rehabilitation of the victim or the bully after the scenario has taken place.
Dr. Veldon, as part of your involvement with this case, have you interviewed any of the students at Baird Academy?
Yes, I have.
What, if any, information did you obtain from these interviews?
Through these interviews, I found that the students at Baird Academy were indifferent to bullying due to their competitive nature. They were in such a prestigious and rigorous high school trying to get ahead of one another that what the rest of the world constructs as bullying, that they don't see as bullying.
Dr. Veldon, have you reached an expert opinion as to whether or not the Baird Academy anti-bullying policy could have prevented bullying within the culture that existed at Baird?
Yes, I have. In my expert opinion, absolutely not. The bullying policy in place at Baird could not prevent bullying, nor could it stem the tide of bullying once it had begun.
Are you familiar with Alex Sultan's mental condition prior to his enrollment at Baird Academy?
Yes, I am. He was suffering from subclinical depression due to the tragic loss of his parents, as well as the shocking change of environments from Semaphore Heights to Huffington Falls.
As part of your involvement with this case, have you met with Alex Sultan?
I met with him at the Mall E. Solon Recuperative Center.
What, if any, medical records have you reviewed in this case?
I reviewed his diagnosis and treatment at the Mall E. Solon Recuperative Center.
Two more questions?
After meeting with Alex and reviewing his medical records, have you formed an opinion as to whether or not Alex suffered any additional psychological harm as a result of the bullying incidents at Baird?
Yes, I have. He was already suffering from subclinical depression due to the loss of his parents and the change to a new school, a new town. However, the bullying he endured at Baird did exacerbate his already existing condition.
Dr. Veldon, in your expert opinion, was this additional psychological harm suffered by Alex the result of any action or inaction on the part of Mr. Sway?
In my expert opinion, absolutely not. Mr. Sway intervened appropriately when he saw instances of horseplay in the hallway, and he even asked Alex after the fact if he was okay. Mr. Sway himself was not responsible for the culture at Baird Academy among the students that was indifferent to bullying. Mr. Sway was in favor of a stronger policy, and Mr. Sway himself did not bully Alex. That was Nate Crope.
Nothing further, Your Honor.
You may cross-examine.
Good morning, Your Honors. I'd like to reintroduce myself at this time. My name is Sam Farnsworth, and I will be conducting the cross-examination of Jean Veldon.
You may proceed.
Good morning, Professor Veldon.
Good morning.
Now, on October 21st, Alex Sultan was subjected to an atomic wedgie, physically assaulted, and ruthlessly cyberbullied, wasn't he?
Objection, Your Honor. That is a compound question.
Make it more sustained.
Okay. Now, on October 21st, Alex Sultan was subjected to an atomic wedgie, wasn't he?
Yes, by Nate Crope.
And he was also physically assaulted on that day, wasn't he?
By Nate Crope, yes.
And also on that same event, he was ruthlessly cyberbullied, isn't that correct?
Not necessarily, whereas the pictures of Alex were still up on the Friend Connector. They did take videos and postings of him, but none of those...
Now, Dr. Veldon, you are aware on that day that people took pictures
Your Honor,
and posted
I would
them online.
request that you allow my witness to answer the question.
Sustained. Don't cut him off. You wanna
I'll
finish your
repeat the
answer?
question for you so that you may, so you can answer it. You are aware he was ruthlessly cyberbullied on that day as well.
Yes, well, the pictures were already up, and because they were up, that is cyberbullying because it is constant. However, the photos and the videos that his friends were taking and sending to each other does also count as cyberbullying, but that was quickly and swiftly dealt with.
So you are aware that the people were also taking photos and posting them online that day?
As I just said, yes.
And that night, Alex Sultan was hospitalized due to his mental state, wasn't he?
Yes, and he was given a sedative to calm down.
Now, in preparation for this case, you met with Mr. Sway, didn't you?
Yes, I reviewed his affidavit as well as meeting with him.
And you found that he had 15 years of teaching experience, isn't that correct?
Yes.
And you also found out that he had been trained for 2 years prior to the 2009 experience with Alex Sultan by Baird on bullying prevention and recognition, correct?
Well, the seminar was held by Dr. Moisen, and he was poorly trained, yes.
And this took place in 2008 and 2009 before the school semester began?
Yes, very brief seminars that did not properly address it.
And you also reviewed the Baird policy and found that it was in correspondence with Massachusetts law, didn't you?
No, I did not.
You did state in your affidavit that it did meet the minimal requirements, didn't you?
No, I did not.
But Mr. Sway is bound by both Massachusetts law and the Baird policy, isn't he?
Well, he must comply with the policy, but he must follow the law. It supersedes the policy.
So Mr. Sway is more bound by the law than the policy itself, as you just stated.
He is bound by the law, yes.
Thank you. Now, you also stated that you believe that the disciplinary matters at Baird Academy are inefficient, didn't you?
Correct, because it does not comply with Massachusetts general law.
But you didn't meet with the headmaster, did you?
No, he was not available to me.
And he is the head of the disciplinary committee at Baird, isn't he?
No, he's the head of the subcommittee, whereas he's a part of the disciplinary committee.
And as you heard before, he can deal with all disciplinary matters on his own, can't he?
Objection, Your Honor. This witness would have a lack of personal knowledge on this issue. He has no experience dealing with the Baird Academy disciplinary committees. He was not familiar with that. He did not meet with Mr. Hertwich, and this line of questioning is outside the scope of this particular witness.
Your Honor.
Sustained without a foundation. You can ask it again if you can lay a foundation that he would have that information.
Your Honor, I believe I laid foundation by asking if he had met with the headmaster before, and I believe this goes straight to the quality of his testimony on the disciplinary matters at Baird as it was addressed on direct examination already. It's calling into question his credibility as he did not meet with the headmaster, who is the sole member of the subcommittee and can deal with all disciplinary matters on their own.
Ask the question again, please.
The question at this specific point was, I believe that it was the headmaster can deal with all disciplinary matters on his own, I believe was the one I was on at this point.
He's already answered that question.
And then the following question, if it was, and the whole headmaster can act as the sole member of the subcommittee.
Only if he knows, and you can redirect him on that. You can answer it if you know the answer.
Can you repeat the question, please?
And the headmaster can act as the sole member of the subcommittee. Isn't that correct?
The headmaster is the sole member of the subcommittee.
And you didn't find it important to meet with him?
No, because the subcommittee, all it does is decide whether or not the disciplinary committee should be moved up. So the disciplinary committee is the full committee, and they have the only power to expel or do anything with someone. So that is why I met with Sway, because he is a member of the disciplinary committee.
Motion to strike everything after I believe it was yes, as unresponsive to my question.
Overruled. No, you can ask them three more questions.
Three more questions. I would ask for additional time as there was a long objection which ended up being overruled in the long run.
All right,
May I
go
have
ahead.
5
Let's
questions?
Go ahead.
Now, in this case, Mr. Sway witnessed Alex Stolten being cornered in the hallways and with people playing keep away with his possessions. Isn't that correct?
Horsing around as friends do, yes.
And this constitutes bullying, doesn't it?
No, it does not.
But you stated in your affidavit that the totality of the events experienced were bullying, didn't you?
Because it takes a pattern of bullying as well as repeated events of bullying. The events in which Mr. Sway did witness could not be construed bullying at the time until it escalated to the point of the physical assault on the field.
May I proceed with a few more questions? Thank you very much, Your Honor. And there was also cyberbullying in this case, wasn't there?
Yes.
And Mr. Sway claims that he became aware of this on October 20th. Isn't that correct?
Very late at night, yes.
And he did not report this until noontime on October 21st. Isn't that correct?
Because the Massachusetts general law requires a prompt response in all bullying scenarios that do not end with imminent harm to the subject. So because there was not an immediate response required, a prompt response would have sufficed perfectly fine, which was within the 14 hours that he did eventually report it.
That was not my question. My question was, he did not report this until noontime on the next day. Isn't that correct?
Because there was no need, yes.
And this was the first official report he made. Isn't that correct?
Well, he did give an oral report, but that wasn't officially claimed, so yes.
Thank you. No further questions at this time.
Yes.
May I proceed with redirect, Your Honor?
Yes.
Dr. Valdon, within the culture that existed at Bayard Academy, would it have been possible for Mr. Sway to recognize a pattern of bullying against Alex Stolten?
Absolutely not.
Dr. Valdon, as a result of cross-examination, have any of your opinions changed?
No, they have not.
Nothing further.
Yes, Your Honor. So you believe that there is a culture of bullying, culture reluctant to confront bullying at Bayard Academy, is that correct?
Just among the students, yes.
And is Mr. Sway part of this culture?
He is not a student, he is a teacher, so he is not a part of this culture, no.
Thank you, Your Honor.
Anything else? All set. Thank you. Anything else for the defense?
The defense rests, Your Honor.
Both parties having rested, we're going to take a brief recess before the closings.
The court all rise. Quiet, please. Quiet. The court may be seated. Court is now session.
Thank you. Both parties having rested, it's now time for closing statements. Let's find them.
May I proceed, Your Honor?
Yes, you may.
Your Honors, today you have heard a case about indifference. Indifference that did not occur on the part of my client, Mr. Alan Sway, but indifference which occurred on the part of the entire administration at Bayard Academy. My client, Mr. Alan Sway, was a dedicated, loyal, and experienced teacher for over 12 years at Baird Academy before these events occurred. But as a teacher at Baird Academy, Mr. Sway was surrounded by a culture of competition and a driven culture, and one that turned a blind eye towards issues of bullying. As a homeroom and a math teacher, Mr. Sway was not only responsible for handling administrative tasks such as announcements, special notices, and attendance, but he was also responsible for 5 classes worth of homework, papers, and tests. You've heard Mr. Sway tell you today that he saw over 100 students each day, not to mention all the students that he saw in the hallway. Mr. Sway was overburdened by the expectation of dealing with disciplinary issues and monitoring the social lives of his students. Mr. Sway was adrift in a sea of administrative indifference at Baird Academy, a type of administration that turned a blind eye towards bullying issues and was more concerned with the reputation of the school than with the well-being of their students. Despite this, Mr. Sway acted in accordance with the Baird anti-bullying policy and with Massachusetts general law, and therefore it is wrong to suggest that he was negligent in the case of Alex Sultan. Today, Your Honor, the plaintiff has failed to prove by preponderance of the evidence that my client was negligent. Negligence, as the court is aware, is defined by the case of Altman versus Aronson as the failure of a responsible person, either by omission or by action, to exercise that degree of care, vigilance, or forethought, which, in the discharge of the duty then resting on him, a person of ordinary caution and prudence ought to exercise under the particular circumstances. Furthermore, the plaintiff has failed to prove by preponderance of the evidence that my client breached his duty of care to Alex Sultan. In the case of Yakubowicz versus Paramount Pictures Corporation, duty is defined as a basic principle of negligence law, is that ordinarily everyone has a duty to refrain from affirmative acts or omissions that unreasonably expose others to risk of harm. Your Honors, today you have heard 3 witnesses for the defense testify today. The first was Jody Trask, a graduate of Baird Academy. You have heard Jody Trask, as a member of the disciplinary committee, told you that he had direct experience with the indifference of Baird Academy towards bullying issues. He told you that to the best of his knowledge, Headmaster Hurtwich was the sole member of the subcommittee. And despite the fact that many bullying reports were filed, and many reports were filed of sexual misconduct of hazing by Mr. Trask himself, Headmaster Hurtwich did nothing in response to these. The plaintiff on cross-examination has attempted to assert that Mr. Trask would not have been aware of Headmaster Hurtwich's actions because his reviewing of reports was confidential. But as a member of the disciplinary committee, Jody Trask would have been fully aware of Headmaster Hurtwich's actions after he reviewed those policies and his actions in accordance with how he should have punished the students that were guilty of bullying incidents. The second witness you have heard from was Mr. Alan Sway, my client and the defendant in this case. You have heard Mr. Sway tell you that he reached out to Alex Sultan on multiple occasions. You have heard him tell you today that he reached out to Alex, he gave him his cell phone number, but Alex Sultan never called Mr. Sway. Alex Sultan never told Mr. Sway that he was being bullied, and furthermore, Alex Sultan looked Mr. Sway in the eye and he told him that everything was cool and that everything was okay. Despite this, Mr. Sway turned around and spoke to Headmaster Hurtwich in the hallways and told him that some of the boys in school were roughhousing with Alex too much. Mr. Sway exceeded his expectations as an educator and a teacher at Baird Academy. On cross-examination today, Your Honors, the plaintiff has attempted to analyze and scrutinize every single one of Mr. Sway's actions from 3 years after these events have occurred. 3 years after these events have occurred, they are looking back on each event from 20/20 hindsight. And we remind you that 3 years after these events occurred, it is easy to point fingers at my client. But my client was not negligent in the case of Alex Sultan, and he did everything he could in his power to protect his students from damaging incidents and students such as Nate Crope. The last witness you have heard from was Dr. Jean Valdone, a clinical psychologist involved with the development of programs dealing with bullying issues in elementary and secondary schools. Dr. Jean Valdone told you today that the present condition of Alex Sultan was a proximate cause of the bullying he suffered from today. You have heard both Dr. Moisen and Dr. Jean Valdone tell you that Alex was experiencing depression before he even entered Baird Academy, And because of this, the cyberbullying, and the incident of physical assault on October 21st was a proximate cause of Alex's current condition. But, Your Honors, the action or inaction of Mr. Sway had no bearing on Alex's present condition. The defense has also called 3 witnesses to the stand today. The first was Ben Sultan, the second, Jamie Wong Nagarola, and the third, Dr. Israel Moisen. Again, you have heard Dr. Moisen tell you that Alex was experiencing bullying before he entered Baird Academy, making this a proximate cause of his current condition, not Mr. Sway's actions. All 3 of these witnesses have attempted to blame my client for the bullying and for Alex Sultan's present condition. However, Mr. Sway did not bully Alex. Mr. Sway is not a guidance counselor. He is not a school psychiatrist. He is not a law enforcement officer. He was not the headmaster at Baird Academy. He did not have the power to suspend or expel somebody on his own. And he was not in any position to take action. The headmaster Hertwich was responsible for this. But despite this, Mr. Sway exceeded his expectations as a teacher. And as soon as bullying incidents were made aware to him, he was sure to promptly report them to protect Alex Sultan. Furthermore, Your Honors, thank you, Your Honor, I'm almost done. Furthermore, Headmaster Hertwich was not called to testify today. You have heard that there is not a scintilla of evidence to prove that Headmaster Hertwich would have acted if Mr. Sway had done anything at 10:30 p.m. on the night of October 20th. And therefore, it is speculation to assert that if Mr. Sway had done anything, then the physical assault on October 21st would not have happened. Therefore, it is not correct to assert that my client's actions were a proximate cause of Alex Sultan's present condition. For these reasons, Your Honor, we ask that you find my client not negligent and that his actions were not the proximate cause of Alex Sultan's current condition today. Thank you.
Thank you. Closing argument for the plaintiff.
Good afternoon, Your Honors. May I proceed?
Yes, you may.
Your Honors, we trust teachers. We trust them to protect our children. Mr. Sway did not protect Alex from the bullying he endured from the moment he enrolled at Baird Academy. Not only did he not stop the bullying when he should have, he did not even report it. Your Honors, today we had to prove by a preponderance of the evidence that Mr. Sway was liable for negligence, that he owed a duty of care to Alex Sultan, that he breached that duty, that Alex suffered a harm, and that that harm was caused by Mr. Sway's breach of duty. Today, you heard about how Mr. Sway was an experienced and trained teacher. You heard that he had attended 2 of the Baird Academy anti-bullying and prevention trainings prior to Alex's enrollment. You heard directly from Dr. Moison that during these trainings, she provided Mr. Sway with a copy of a model bullying prevention and intervention plan, which was in-depth and would provide guidelines on how to identify bullying, as well as a list of indicators on how to identify bullying. Your Honors, Dr. Moison went over specifically the situation where a victim of bullying denies that they're being bullied. Yet despite all of this information, Mr. Sway did not make a report. Mr. Sway owed an additional duty to Alex Sultan under Massachusetts law and the Baird policy. Your Honors, today you heard that teachers are required to report bullying. And in Massachusetts law, they're required to report any bullying that they become aware of immediately. Today, you heard of repeated events of bullying directed towards Alex Sultan. Let's review these. You heard how Alex Sultan was called names in the classroom while Mr. Sway was present. You heard that Mr. Sway was there while people said derogatory comments about Alex Sultan. Mr. Sway saw Alex being cornered in the hallway by bullies as they played keep away with Alex's possessions. Mr. Sway saw Alex Sultan tripped in the hallway. Mr. Sway watched as Alex Sultan isolated himself, and then watched as Alex Sultan became withdrawn. This raises the question, how does an experienced and trained teacher dismiss this totality of bullying as typical teenage behavior? Your Honors, the answer is that there is a culture at Bayard that is so ingrained that teachers there don't recognize bullying when reasonable teachers would have been able to see that Alex Sultan was being bullied. Your Honors, the defense has tried to claim that Mr. Sway is not part of this culture. And if he wasn't, then he truly should have been able to identify that Alex was being bullied and should have made a report. But the facts are that he didn't. Your Honors, today we also had to prove that Mr. Sway's negligence was the proximate cause of Alex Sultan's injury. Proximate cause is defined as, but for the negligence, the injury would not have occurred. Today, you heard how if Mr. Sway had reported the bullying earlier, the final assault of Alex Sultan would not have occurred, and he would not have suffered the harm that he did. If Mr. Sway had stopped the bullying beforehand, Alex would not be in a hospital with psychiatric care at this moment. Your Honors, in the case of Casey versus General Motors, it was found that an expert's opinions based on the facts and evidence is sufficient proof of causation. Today you heard from Dr. Moisan, who testified that Mr. Sway's negligence was directly responsible for Alex's mental breakdown. The defense would like you to believe that Alex had a pre-existing condition, that he was already damaged when he entered Bayard Academy. However, you heard from Dr. Moisan that Alex Sultan was on a path to recovery, that he was doing a lot better when he entered Bayard Academy and would have fully recovered if the bullying had been stopped. You heard from Ben Sultan, similarly, that Alex was recovering and doing a lot better, and that he was stronger when he entered Bayard Academy. Your Honors, it was found in the case of Friar Smith versus Lufty that when an accident activates a dormant or incipient disease, the negligence that caused that accident is the proximate cause of the disability. In this case, the bullying, and specifically the final assault of Alex Sultan, deepened his subclinical depression to a depression so severe that he has been unable to leave the hospital since October 21st, 2009. Your Honors, one does not have to be a psychiatrist or a guidance counselor or some law officer to notice bullying and report it. Teachers have a duty to report bullying. And Mr. Sway did not report bullying when it was evident that it was present. Mr. Sway did not stop the bullying of Alex Sultan in time to prevent his complete mental breakdown that caused his hospitalization. We ask that you find today that the defendant, Mr. Alan Sway, is liable for negligence. Thank you for your time.
Thank you.
Under Rule 905, a closing argument is limited to facts brought out during the case today, and I have one objection to the closing argument. My opposing counsel mentioned the model bullying policy created by Dr. Moisan, but that was not entered into evidence during trial today, and I would therefore like to strike that part of the closing argument from the record.
While it was not entered into evidence, it was brought up and talked about during the trial today. As I did not testify as to specifics of the document, and only as to its existence, I believe it is admissible.
Thank you. I know what you say. I'm going to leave it in as argument. It's argument. Okay. Thank you.
Quiet, please. Quiet, please. session. You may be seated.
How's everybody doing? At this point, I would like to ask the presiding judge to come forward to give the ruling of the panel on the merits of this case had it been an actual trial.
This was a very difficult decision to make, and we were not unanimous in our decision, but the majority rules, and the majority rules for the plaintiff.
I know that's not the one that everybody's still waiting to hear. I would like at this point to ask each of the judges to come forward and give just some brief remarks, overviews of what they thought they saw today and what they appreciated. In whatever order you want.
Judge Liu is really, really good because in the Superior Court, seniority is everything. And he's deferring to less than seniority. First of all, let me say on behalf of all the judges, I'm sure everybody will say this, is fabulous job, guys, really. I've had the pleasure of seeing both of these teams before in front of me in the Worcester Court, and you guys have improved tremendously over the last year. Some of you have even gotten taller and older looking, which is always nice. I'm going to just make some just general remarks. And I'm sure that some of these, I mean, please, you guys are great. This is nitpicking, okay? Because you're going to want to learn from this. This is a nitpick for me generally. I hate having a bottle of water in front of me, and I hate seeing bottles of water necessarily. I don't mind them on the tables. But I really think in a courtroom, and this is a personal thing, you look a whole lot better drinking it out of a cup than you do drinking it out of a bottle. Why? I don't know. It's a thing. Call it age. I didn't used to be this way, and I drink Diet Coke out of a can all the time. But when I'm on the bench, I really feel that there's a formality to a courtroom such that you should have a cup. So just as a word to the attorneys and everybody else, if you have a bottle of water, that's great, but there's nothing stopping you from pouring it into a cup and drinking out of a cup. It just looks better from the perspective, and I've had jurors tell me that too, is why are they drinking out of the bottles of water? It just looks unprofessional. But it's not your fault. You all did, and we all did exactly the same. Just one note. All right. All right. One of the things that I see, and I see this often, and I saw a little bit of it today, but not much, is when the court rules in your favor on an objection, some of you, every once in a while, would say, thank you. Objection, sustained, thank you. Objection, overruled, thank you. Don't thank the court, okay? It makes it look like you're going, hey, thank you. You know, that's what it sounds like. So just as a little word to the wise. You don't need to thank the court for sustaining or overruling objection. You can thank the court later for other things, but that's just one note. All right. This was the biggest issue that I saw on cross-exam, and this was true everywhere. Do not interrupt the witness mid-sentence. Some of you did very appropriate objections to that. It is very insulting to the witness. It's very insulting, and it doesn't give you points as an advocate. That is not the way you control a witness on cross. And I feel that the way to control the witness is, sure, let him answer. And then say, as you did, and many of you did at times, Judge, I move to strike so much of everything that went beyond yes or no. And when you do that multiple times, the trier of fact, whether it be the judge or the jury, starts to go, oh, there goes that witness again, running over. But if it affects you so much that you start interrupting, the jurors and the finder of fact start to get annoyed with you. Not because you're doing it necessarily wrong, because you're right, they are going beyond the scope, but rather because it sounds like you're being rude and disrespectful. So try not to do that. Another thing is a general rule. Use your fact witness to give facts for you to use in argument. Try not to phrase your question as an argument that you want the judge to hear. So, and this happened, and it's a kind of again, I'm nitpicking here, so please. You know, if you want the judge to understand that Ms. Sway or Mr. Sway didn't report, you don't have to belabor the fact that if you didn't report it, you didn't call, you didn't do this. Yeah, we got that. But get this person to give a series of yeses or nos or whatever on cross, for instance, or even in direct exam, to tell the story so that then you can get up in a closing argument and say, and the witness said this, and that means that. So your question shouldn't necessarily be your argument, okay? Experts. An expert is a teacher in a courtroom, and all of you did a fabulous job with the experts. And one of the things that I saw, which we don't often see, which is unfortunate, is the attorneys don't always allow the expert to just say what needs to be said. They tend to kind of want to say it for themselves. And so you need to always remember an expert witness knows more than anybody else on this particular topic. That's why you call them. You want that expert to teach the fact finder. So use it as a teaching tool. And with the opposite expert, find those little places on cross-exam, when you're cross-examining an expert, find the little places in the report or whatever that is consistent with your expert's view of the case, so that you actually can use the opposite expert or the next expert, the opposing expert, to help you prove your case. This is just another general thought. You guys are under terrible time constraints, and I apologize for not always hitting the button at right time, so I kind of let you go or not. And it's hard to keep track because I kind of get into the talk, and I go, oh my God, we're at 5 seconds. You did a really good job on the time, but because you have that time gun to your head, you all talk really, 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 really fast. And that's hard for us sometimes to follow, particularly in a building like this where the acoustics are everywhere. And so sometimes we don't always catch things and hear things. So when I felt for Judge Pearson, who had to rule on objections, and I was really glad I didn't have to, because what'd you say? Sometimes we don't always hear it all. And when you're interrupting each other and jumping up, they muddle and we don't hear it. So think about your time that you have in which to conduct this, but think about slowing down your speech so that the person who's hearing you actually can absorb it, okay? So those are just a few general remarks. And I think I'll get off this stand and defer to its seniority and allow Judge Liu to say what he needs to say. Thank you.
So my name is Jack Liu. I'm from the Superior Court as well. So Judge Kenton Walker knows, of course, that seniority is code for age and is basically an insult. But that's okay. So I think I have 6 or 7 points that I'm going to make quickly. I'm going to leave my notes with Josh, and you folks, I use a very consistent shorthand. I'm sure you can figure it out. There are some extremely specific comments on each of these wonderful young people that I hope will be helpful. Now, and I also want to say, and I have a lot of experience like everybody else. I teach at 2 law schools. I have done innumerable mock trials as a judge and other things, and I am amazed by the quality of, and I participated last year, a lot of you may remember, and I'm amazed at the quality of the advocacy here, and I congratulate the participants, but even more so the parents and the teachers for what you have brought about here. It is amazing, impressive, and it really warms my heart as a parent to see this. Now, here are my comments. I'm going to give them generically because we don't have time to go through by person. So everyone, and this was an attempt perhaps to help in future competitions as well. So, so as I get up here ready to insult my fellow judges, for example, I kind of judge how this microphone works through my ears and whatnot. So this is the most challenging venue you're ever going to try a case in. So when you stand up, in that first 60 seconds in which you're talking, you got to figure out what the distance from the microphone is and the volume is necessary so that everybody can hear. I mean, is anyone having trouble hearing me? Yeah, that's because I have a microphone here and I'm adjusting my distance and volume. And this is just the worst possible venue, even though it's an incredibly historic place. So figure out the microphone in that first 60 seconds you stand up. Movement. The ideal movement for a trial lawyer is extremely controlled but purposeful, but there is some movement. So yeah, it is better not to move. It's better not to move than to move all about like a crazy person. But it is better to have very controlled, purposeful movement for rhetorical effect, for dramatic effect, but to have some movement. So you folks are so stellar at this that you have too little movement. And that's impressive for folks of your experience level. But you want to have a little more movement and use it for dramatic effect. You need more variation in tone and volume and speed. And yes, you do generally need to slow down. You have amazing detailed knowledge of the rules of evidence, and I can tell you that it's just common sense that any chance you get to display your knowledge of the rules of evidence, if there's a meter running that shows how many points you're getting from the judge, it's starting to spin when you show detailed knowledge of the rules of evidence. So, and you saw that during the trial when some people did that. That's going to gain you points if you can, without much advance notice, sometimes with zero advance notice, nail an arcane provision of the rules of evidence. Have in mind the classic theory of cross-examination. It doesn't necessarily mean you always have to do it, but the classic theory of cross-examination is that you transition from friendly to unfriendly. So being real nice to the witness who you're trying to damage, after all, to gradually becoming unfriendly. So the first words out of your mouth in the first part of your examination should usually be very friendly. So you go friendly to unfriendly, and you'll get much more that way. My last point, well, I'll make one other kind of tiny point. And I recommend that when you have anything involving documents, if you're in front of a multi-judge panel, that you give the presiding judge a copy and the other judges a copy of everything. Even if you're just asking for a ruling on some document, and if you're giving a witness a document, you should give all of the judges copies of the documents. It's a parallel to what we call a jury book, that the jury looks at extra copies of all documents being looked at by a witness. My last point relates to the closing argument. These were both top level closing arguments. They were wonderful. Everything here was wonderful. After all, this is the state championship. This is the best of the best. But the very best of the best closing argument, and I'm really talking about experienced trial lawyers, must have a theme, and that theme must be hammered at over and over and over again. So, and I don't know, maybe that was a 7-minute closing argument or a 5-minute closing argument, or a 7-minute closing argument. It is not an exaggeration to say in a 7-minute closing argument, you should hammer at that theme probably 6 times. The first words out of your mouth should be about your theme. You should hit at it 4 or 5 more times during your argument, and then nearly the last words out of your mouth should be about your theme, and it should be an inspiring and uplifting theme that has a lot of persuasive effect. Thank you, and you have my congratulations.
Can you give another set of applause to the parents and the coaches and your teachers? This is tough. I watched the basketball last night, and you can imagine the parents just sitting at the edge and all the rooters, as I call them. And you all had that today. You are so blessed to have a wonderful group of people who are behind you, in front of you, and have helped you through this process. And you have been stars, all of you. It is remarkable to me, and it's a joy to be able to stand here. It was humbling and an honor for me to rule on your objections that you made that were not very easy to rule on, and especially because, as Judge Liu said, the acoustics were terrible. And I could get part of your question, and I couldn't get all of it, and then I got the objection, and I was like, oh my goodness, I didn't quite hear all of the question, and I'm trying to write notes about what it is that you're doing well and not doing quite as well. And so it was a lot of work for me. I'm more exhausted today than I've ever been. I like to sit as a second judge much more. But it was terrific, and really you should be so proud of yourselves. I just have a couple of comments to add to those of my colleagues. First of all, as witnesses, you were great. And witnesses, you're actors. And I know that Pioneer Valley is a school where it's a charter school of acting. Is that right? Part of it, theatrics. So you're stars, but Marshfield High School, you were stars too. And it's not easy to stay in those roles, as you know, especially when you've got really good cross-examiners who know everything you're about to say, and they know, how you said it before and how you're going to say it again, and you've played both roles. It's a toss of the coin, isn't it, as to what side you're going to be on? So everybody knows it just perfectly well, and all 6 of you stayed in your roles terrifically, and that makes a lot of the case. This is mock trial. And even in real trial, you'll read about cases rise and fall on the witnesses. So you're all star witnesses, which made it very difficult for us, too. The attorneys, you were just wonderful. I wish that all the attorneys, and there are a few people in this wonderful hall who appear in front of me quite regularly, who are all very good. But they could learn, many of their colleagues could learn a lot from you because you were just terrific. I'm going to suggest that as an attorney, you present evidence. This is not your best friend who is the victim or the plaintiff or the accused or the defendant. This is your client, and you owe a responsibility to that client to zealously advocate for that client, but it's not, I would suggest that you not become emotionally involved, and most of you did a really good job of being dispassionate and present. And as Judge Liu said, there are some theatrics that come with presenting evidence, and there are ways to do it in a more effective way than others, but you captivated, I think, what your roles were as attorneys very well. But keep in mind that your job is to present evidence and let the witness speak. Reiterating again, let the witness finish what he's speaking, even if you don't like what he's going to say, because that's what cross-examination is about. If you don't like what a witness says, or then you can either rehabilitate that witness if it's yours, or you can tear down what he said in a more effective way. And yelling at witnesses doesn't get anybody anywhere. You want to be aggressive, and you want to show the court that witness is not going to say what you want. But yelling at the witness, cutting off a witness, is not an effective way to do that. I suggest that, and I don't know if you do it in the finals, if you have one judge or a panel of judges, but make eye contact with each of them. You did a great job of making eye contact with me. Make sure that you look at all 3 judges as well. You are invested, you are bright, you give us great confidence in the future of this country with all of you as leaders, and I couldn't be more excited to be here. I have the responsibility, before I do that, I do want to recognize our court officer, Elliot Posada, who came here from court to help us, and thank you. Thank you. And thank you to our sponsors and to our leaders of the Mass Bar Association. And I know that you just can't wait to hear me tell you who won. It was not a unanimous decision. It was 2-1. It was difficult. We talked about it, and we are just so impressed with all of you. But someone has to win, and someone has to lose. When you lose, you are not really losing. You are winning the opportunity to continue with this. I don't know if any of you are seniors, but you have opportunities in the future and throughout your lives to continue with this. So take that as a win for both teams. But the winner of the Massachusetts mock trial, who will take Massachusetts to Albuquerque, I believe, is Pioneer Valley.
Could we have a representative of the state champion team come up for a presentation on stage, please? One representative, please. And at this point, I'd like to bring to the podium the president of the Mass Bar Foundation, Jerry Cohen, for a special presentation to the winning team.
Good afternoon, and congratulations to all of the 122 schools that participated in the program. Know that the winner is declared as Pioneer Valley, but you're all winners. You all worked together to make it happen, and the winning team was sharpened up by competition with the others. At the Mass Bar Foundation, we work all over the state as a voluntary group of lawyers raising money for civil legal aid, especially for those who are most indigent and most in need of it. It's an endless task. As you know, the needs are very great, but it's so important that everybody shall have access to legal aid, and legal aid of a high level of skill and dedication, such as our teams have dedicated today through hard work. We work to raise money, we work to raise consciousness, we work to raise volunteer efforts and participation, both in our fellow attorneys and in the public at large. Events like this help us to meet those goals. Our contribution to this event is to deal with the very important task that now that we have a winner, how do we get them out to Albuquerque? The answer is here. It looks like a skateboard, but it's not. It's, can I have the team come up to accept it as a whole?
Would,
Sure.
I can.
You can accept it for them, but why don't we bring the whole team up?
Okay. It is a team effort that gets us.
That's right. And that's why I felt that. The skateboard is only a mock-up of a check. A real check will be presented later. It's a check for $2,500 to help with the expenses of getting to Albuquerque and back. We know you'll go there and do us proud. Congratulations. Put your hands together for this wonderful time. You can hold on to it. We'll trade it for a real check later.
Thank you and congratulations. And if I could, we have a picture?
Would you like to? Here. You guys hold
Yeah, you guys are finished. If I could have a representative of the Marshfield team as well up on stage. Thank you all once again for coming and for participating. Congratulations to the state champs. Good luck at nationals. Thank you.